Good afternoon, everyone. Welcome to the Judicial Proceedings Committee. Today is Tuesday, February 20th, 2024. We have 15 bills on the docket, and we're going to start off with Senate Bill 568. Senator Hettleman, if you'd like to bring up your sponsor panel, welcome back.
Thank you very much, Mr. Chairman, Mr. Vice Chairman, members of the committee. We are presenting to the committee today a familiar bill. We've been here a few times. This is Senate Bill 568. For the record, I'm Shelley Hettleman from District 11 in Baltimore County. This is a bill to address SLAPP suits, strategic lawsuits against public participation. And this is really a bill about protecting the little guy. It's about protecting any one of us from a SLAPP suit, a meritless lawsuit filed by someone with deep pockets meant to slap us down, to intimidate, and to make us willing to forego our First Amendment rights and drop our suit because we can't match the plaintiff's extraordinary resources. The First Amendment is fundamental to our democracy, and that was reflected in our action when Maryland was one of the first states in the country to enact a SLAPP statute. It's vital to our democracy to protect our ability, or our homeowners association's ability, or our newspaper's ability to speak on matters of public concern, to share with our local county councils or the public what we think about a development project, for example, or any number of public issues. It's vital that our constituents have the ability to participate in the public marketplace without being threatened by a meritless lawsuit by a developer or an individual who has the resources to intimidate and quash free speech. That was the aim of our forebearers, the legislators who enacted our original SLAPP suit. But our law is flawed and has recently earned a D by the Public Participation Project because of its insufficiency. The bill before you today, Senate Bill 568, strengthens our law. The purpose of Maryland's anti-SLAPP law is to enable a judge to dismiss such suits early in the litigation process, doing away with the burden of lengthy and costly litigation and to preserve the defendant's right to free speech. The bill does three very important things. It eliminates the bad faith requirement from a SLAPP suit. This requirement places an undue burden on the vulnerable defendant and provides an unnecessary protection for the plaintiff, contrary to the purpose of the law. The bad faith requirement not only asks defendants to show that the suit brought against them is meritless, but that it rises to the level of bad faith. Two, it also enables attorney's fees to be shifted, which creates a deterrent to a deep-pocketed plaintiff. And third, it requires courts to act promptly to hold discovery until there are expeditious rulings, and that serves as a screen. One last thing, this bill is agnostic with regard to politics and perspectives. SLAPP suits have been filed from the right and from the left. And as you will hear, strong SLAPP statutes serve to protect all who have been wronged in this arena, protecting the First Amendment without regard to politics. In years past, we have come before you with some folks in the media world. We decided to take a little bit of a different approach this year. And we're going to talk about it from a couple of different perspectives. And I will pass it on to my two panelists here who can further elucidate why we need to reform our SLAPP law. Thank you very much.
Thank you, Senator Hettleman, and good afternoon, members of the Judiciary Proceedings Committee, Mr. Vice Chair, and all the other members here today. I'm Katie O'Malley, and I'm back again to testify before you with regards to this issue of the SLAPP suits and a perspective of the Women's Law Center of Maryland, which I'm now the executive director of. These suits, again, as the senator said, here in Maryland, we've received a D on our anti-SLAPP legislation. And by doing the things that the senator just talked about, that will help get us up to perhaps a B or maybe even an A. But as a statewide legal services organization, we strongly believe in the right for all people to petition the courts, regardless of what their issues are. Yet we also believe there needs to be a balanced approach, especially when individuals, particularly those wielding power, utilize the court as a weapon against those who speak out against abuse. And that's particularly true with the citizens and with the victims that we deal with at the Women's Law Center. Survivors across the country are facing lawsuits brought to discourage them from exercising their rights in Title IX cases, college sexual misconduct proceedings, for bringing protective orders in response to intimate partner violence. The result of these malicious lawsuits is to discourage survivors from continuing their pursuit of safety and recourse. While not all of these are retaliatory suits, some of them will qualify as SLAPP suits. So we believe and we strongly urge that there's a favorable position here on Senate Bill 568. And I'm happy to answer any questions.
Good afternoon. My name is Tom Cole, and while I'm a lobbyist here in Annapolis, I'm here to talk to you about my clients and the personal impact of not revising Maryland's SLAPP suit. In February of 2021, my client was sued for defamation related to a blog post that she wrote about a referendum petition drive and the manner in which those signatures were being gathered. I know Senator Hettleman has spoken about deep pockets, but this was a circumstance in which the plaintiff just had a husband as an attorney. I entered my appearance on February 17th to defend her, and on February 22nd, I was sued. I may be the only defendant that had a case dismissed under the SLAPP law for the state of Maryland. It was only because it was so extreme. Plaintiff's lawyer sent me an email asking me to withdraw my appearance. I refused, and the next day he sued me. In November of 2021, one of the defense witnesses in my client's case was deposed. 2 weeks later, she was sued. We filed SLAPP motions in my client's case. We filed SLAPP motions in my case. We filed SLAPP motions in the deponent's case. Only mine was dismissed. The two other cases went all the way to trial. And that's because Maryland's SLAPP law only exists in cases of extreme abuse. Mine was so bad that I took the court's opinion and I sent it on to Bar Counsel. Now, I took the case for my client on a deferred fee. I was not receiving any payment for that. My client otherwise would have had to spend over $100,000 to take that case to trial. We had a defense verdict because there was no reason for her to be sued. She never committed defamation. But other defendants aren't so lucky. Other defendants realize that a lawsuit is an injury in itself, and people will abuse the legal system to hurt people. So for that reason, I strongly urge a favorable report on this bill and pass it out of the Senate. Thank you.
Thank you, Mr. Cole. That completes the testimony for the proponents of the bill. Are there any questions from the committee for the proponents of the bill? Senator Carter has a question.
Thank you very much, Mr. Vice Chair. Senator Heldman, do you have any idea how many years this bill has been brought before the body and what has been the stumbling block to the legislation? Because I know that you are a relatively newcomer to bring it in the Senate, but it was brought in the House for like a pretty long time.
So it's a really good question. I know that actually, I believe the chairman of the committee had been a sponsor of the bill. I'm not sure if it actually in the fiscal note, it goes back to 2021. And it has been Delegate Rosenberg's bill for many, many years. It may have gone before that, but I believe the chairman of the current chairman of the committee also had sponsored at one point. I'm not sure if the vice chair had been a sponsor. No.
So I know,
Okay.
I saw the fiscal note to 2021. I actually believe that this bill goes back maybe 20 years or more. That's what I was trying to get at in terms of like being brought by the body, before the body with Delegate Rosenberg.
So we did have we do have a SLAPP statute on the books. It's just, it needs improving. And at its time, it was kind of at the top of the heap. And as the case law in this area has changed and evolved, we have learned that we need to make improvements to it. So that this builds on the work that was done earlier in terms of, I can't tell you how far back that the effort to reform it has gone, but at least to 2021.
So does the language proposed in the bill, because someone testified that our state was among the worst states when it came to protections regarding these lawsuits, the ability to file these lawsuits. What is the language of your bill aligned with other states? And do you know which one? Can we get a little bit more? I'm just curious, like, is this bill the fix? Is this what other states do, the majority of them?
Yes, it does bring it up to parity. So there's actually a map that this organization, the Public Participation Project, actually has a website that has a map, and they grade each state's. There are dozens of states that have far better statutes than we do, and this definitely brings us up.
And then finally, how prevalent is this
How prevalent are
in
SLAPPs?
Maryland?
So I can tell you there was one in your district last year. It's pretty frequent. I mean, I don't know that it is an everyday occurrence, and the judges here might be able to answer that, but it is not infrequent. As Tom said, I mean, this just happened within the last year, the one in your district. There was one in Harford County just a couple of years ago. So it's a fairly regular occurrence.
Okay, thank you.
Thank you.
Senator James has a question.
Thank you, Mr. Chairman. To the gentleman, the lawyer who just spoke, good afternoon. Could you provide the committee with the report or the letter that you sent on, you say, to the Maryland Ethics Legal
Absolutely.
Ethics? Could you provide that?
Yes.
And then to the sponsor, nice to see you. What is the name of the group that for which we get a D? Is there I don't know if the testimony came in late, maybe their testimony is in here.
No, this is a national organization called the Public Participation Project, and I'm happy to share with you that website.
And they mainly focus on SLAPP suits?
Exactly. They just focus on SLAPP.
Yeah, so I'd like to see that.
Yep,
Thank
happy
you.
to.
Thank you, Mr.
And
Chair.
actually, if I might add,
Oh,
I'm
sure.
happy to, there's a 2016 case in Harford County that I'd also be happy to highlight for you that you might be interested in.
Yes, thank you very much.
Great. Senator West.
Thank you, Mr. Chair. Maybe a couple of questions. First, for the sponsor of the bill, tell me, what is wrong with Maryland's current SLAPP statute? Why is it inadequate by the standards of this national organization? And how does this bill make our statute bring it up to snuff?
So there are really three important things that it changes. One is we have right now in our current law, this bad faith requirement. So that's a very, very high standard. And my understanding, I mean, and the bill gets rid of that bad faith. Second, it enables attorney's fees to be shifted. So that creates some disincentive for these kinds of I would say abusive lawsuits, right? Because if you're on the hook for the other person's attorney's fees. And third is it creates a process for weeding out and shining a light on whether this is really a valid suit or not through the discovery process. So a judge can take a look at the situation and make a determination at the beginning rather than going through the long discovery process that's going to rack up a lot of expense and bills, and determine whether to let it go forward or whether to stop it. So those three changes will definitely improve it.
Okay. And then a question for the gentleman at the end of the table who's, you need to stand up at the podium, whose name I can't recall, and I apologize for that, but I was trying to go through the bill. So you say you may be the only person in Maryland history who's gone through one of these.
At least the last 5 years.
Okay. Why is it, do you think, that you're the only person who's been able to go use the process?
Exactly what Senator Hedelman just spoke to. The
What-
bad faith requirement, having drafted SLAPP motions to dismiss myself, there's no discovery that you're having in response to a complaint. But what you do have on the face of the complaint is whether or not this complaint was filed for the intent of discouraging speech or because there's actually been some sort of damages.
And the bad faith requirement requires you to somehow prove what was in the person's mind at the time that
Exactly.
they drafted. Okay.
Correct.
Thank you.
As an attorney, I tell people all the time when they ask, can I be sued? Anyone can be sued. But whether or not you can be sued meritoriously is a completely different question. And that's what the SLAPP lawsuit gets, the
Okay.
SLAPP law gets to.
Answers my question. Thank you very
Thank you.
much.
Okay, back to Senator James.
Just because Senator West asked a question, it just made me realize, do we replace bad faith with any other standard? That's my number one. And on a motion to dismiss, it's usually, we don't have an evidentiary proceedings, it's based on the pleadings themselves. So is the bill trying to convert a motion to dismiss into another kind of motion? Because they usually are without evidence, but based on the pleading. So I'm assuming maybe the lawyer would like to respond to that, but whoever wants to address that technical question.
Sure. So there's a burden shifting in the proposed law in Senate Bill 568 that would have the plaintiff establish that it is not a SLAPP suit, and instead there's substantial justification for the suit. Fact,
Yeah.
which is a fair standard on both sides of the case, because that is something where the court, and again, when I send you the decision from
Yeah.
my dismissal, you'll see this. The judge, and it was Philip Karoum in that case, was just throwing his hands up saying, I can't find bad faith in these other cases, but I can find it here. Substantial justification, law and fact, that is a low standard for a plaintiff to be able to hit. but it at least provides the court something that they can compare the complaint again. Because remember, in the state of Maryland, we have a pretty low pleading standard. It's
Oh,
more than-
notice pleading. I understand.
Yeah,
I'm a lawyer.
yeah, okay, so, you know, this opens it up a little bit more to say, all right, is this a SLAPP suit before we allow it to proceed?
Thank you.
So additional questions from the committee? All right, seeing none, thank you all very much. That will conclude the testimony for the proponents of the bill. We'll now hear from our opposition panel, Ms. Barber. Ms. Barber, before you come off of mute, if you're streaming this hearing on YouTube, if you could mute the browser or shut it down before you unmute yourself. All right, welcome.
Welcome, Chair Ferguson. My name is Claudia Barber. I'm an attorney. I oppose Senate Bill 568. The Strategic Lawsuits Against Public Participation Bill has grave consequences against public figures by arming citizens with the right to report anything and everything to public entities and rewarding those citizens with ulterior motives who do the reporting with blanket immunity and attorney's fees. This is a win for book banning fanatics and those opposed to diversity, equity, and inclusion policies using First Amendment protections as dog whistle protections. Not even civil rights litigants enjoyed this special attention to resolve a case quickly by making a special motion. On January 6, 2021, now known as Insurrection Day, we saw how people engaged in conspiracy theories, wrongly claiming First Amendment protection for their insurrectionist acts of terror. The First Amendment should never again be used as a reason to harm individuals or destroy human beings. One of the pitfalls of this legislation is that it does not protect innocent victims, such as public figures or politicians who may have rivals instigating stories by using public records, resources, and government agencies to create news stories to smear an opponent. It particularly impacts people of color and their communities when misinformation is spread to newspapers and destroys individuals' livelihood and reputation. In 2016, an ex-judge filed a dubious ethics complaint against me, asking my employer to remove me from office because I ran in a partisan primary. Recently, the Capital Gazette printed an awful harassment story against a county council person. So these are examples of how the anti-SLAPP statute goes the wrong way. Thank you.
Thank you for your testimony here today. Questions for Ms. Barber? All right, seeing no questions. Thank you, Ms. Barber, for joining us today. That completes the hearing on Senate Bill 568. Thank you to Senator Heddleman. It's a special day. We've got the former First Lady, the Attorney General of Maryland, and the Chief Justice of Maryland all with us today. I'm just going to take, speaking of which, I'm going to take just folks in the order in which we have the bills today. And so, Mr. Chief Justice, you are up next. Senate Bill 688, Prince George's County Judgeship Circuit Courts.
Thank you, Vice Chair Waltreicher, members of the committee. I'm pleased to be here today to testify in support of the bill that would add one judgeship in the Circuit Court for Prince George's County. I'm joined here today by the Administrative Judge of the Circuit Court of Prince George's County, Judge Danica Varner-Cotton. And I'll let her do most of the talking, but as the members of the committee are aware, since 1979, the judiciary has used a methodology that is its origins in the National Center for State Courts to identify judicial needs. This year, that methodology identified 6 needs for judgeships across the state for a variety of reasons, including, frankly, space in courthouses. We are asking for one judgeship, and that's in Prince George's County, where there is a certified need, and Judge Cotton can tell you a little bit more about that, but they have identified space and local support, budgetary support for the position and the accompanying positions, which would be a judicial assistant and a law clerk as well. So I'll turn it over now to Judge Cotton and be happy to take any questions.
Good afternoon. I am Danica Varner-Cotton. I'm the Administrative Judge for Prince George's County and the 7th Judicial Circuit. I've been the Administrative Judge since January 2023 and Associate Judge for 18 years. And I thank you for the opportunity to provide information on this bill. We currently have 24 judges, and we are seeking support for an additional judge. Prince George's County has been deemed in critical need of additional judicial services. I just want to give you some information on our statistics. In the last year, we've had 25% surge in filing of criminal cases, 34% surge in filing of family cases, about 25% surge in the filing of guardianship civil cases, and a significant increase in the filing of juvenile cases. We've also had a 34% increase in the request for search warrants that have been filed by law enforcement officers. Our need is critical. We've had meetings with the county budget team, and they are recommending to the county council for approval of additional support. We are lucky in that our courthouse has adequate space available to support a new judge and their staff without the need of additional monies to enhance our physical structure. We have amazing judges who work hard every day. But as our county continues to grow and case filings increase daily, I'm here to show support for additional associate judge, which is supported by the fiscal year study. This additional judge, will allow us to more efficiently and timely provide services to the wonderful citizens that seek assistance from our court every day. Our courthouse in Prince George's County has the highest numbers of visitors of any county building. So I thank you for this opportunity to speak to you today. I thank you for your consideration of this request, and I'm eager to answer any questions that you may have. Thank you.
Thank you for your testimony. Senator Muse.
Thank you very much. Welcome.
Welcome.
I have known the honorable judge for many, many, many years. We're good friends. I appreciate the work that you do there in the courthouse. And I know the need is great. I am in touch with many, many judges for so many reasons, and they are overworked, as many of us are. But I know you all are, and I support whatever you do and whatever you need to help us to have a more effective court as best we can. So welcome, my friend.
Thank you. Thank you very much.
Thank you.
Thank you for that comment. Senator West.
Thank you, Mr. Chair. I've got actually a question for the Chief Justice. And I'm afraid you're gonna have to stand up at the podium because otherwise you won't be on camera. So I was interested in your statement that your standards had identified a need for 6 judges, but we can only deal with 1 because otherwise we don't have room in the courthouses for the 5. How are we going to deal as the years go on? We're not building any new courthouses right now, so presumably there will still be a need for those 5 next year. And as the need for additional judges comes online in future years, how are we going to deal with the problem of no room in the courthouse?
So it's not entirely no room in the courthouses. There's one where the issue is where we're not certain based on the trends that there will be an unidentified need next year and didn't want to come and then not be able to support that in the future. For some of the others, we are in fact engaged in some in efforts to expand in order to deal with that. So one of those is in Harford County, where there is a project underway to build a new courthouse that would have sufficient room. That's in our capital budget this year, and in fact, land has been acquired in order to do that. There's an addition in the district, that's the district court in Harford County. There's an addition that is also in our capital budget to the district court in Washington County in order to provide for an additional courtroom and space in that county as well. So we are working on these issues and trying to address those. In the district court, of course, that's because of the unified judiciary at the district court level. That's something that the judiciary puts in its capital budget proposals when we have a need for that, and we're looking in the future in order to anticipate those. When it's in the circuit court, we of course need to work with the local jurisdiction because those budgetary decisions are made and have to be supported at the local level. So the bottom line is we are looking at ways to make sure that where there is a need, we have space, either ourselves in our budget, working with the other committees in the General Assembly, or with the local jurisdictions.
Okay, well, it sounds like a conundrum, and I wish you good luck in solving it. Thank you.
Thank you.
Thank you, Mr. Chief Justice. Thank you, Judge Cotton. Any further questions? All right, seeing no questions, that concludes the hearing for Senate Bill 688. Mr. Attorney General will now move to Senate Bill 680, State Government Public Welfare Actions, Determinations, and Settlements, and whomever you would like to join on your panel.
Thank you, Mr. Chairman and members of the Judicial Proceedings Committee. For the record, I'm Attorney General Anthony Brown. I'm testifying in support of Senate Bill 680, and I'm joined today by Adam Snyder, Principal Counsel at the Department of Labor Planning. Let me get it straight now. And Julie Cuspo, who's an Assistant Attorney General at the Maryland Department of Environment, and Les Knapp, who is our client, my client at the Maryland Department of Environment. Mr. Chairman, if I can just tell a quick story. First year in the General Assembly, first bill that I ever had drafted. You can imagine how excited you are, right? Think about that day. Who was my bill drafter? Les Knapp. We've now come full circle. He's now a client, representing the Maryland, working at the Maryland Department of the Environment, and here in support of Senate Bill 680. Mr. Chairman, members of the committee, if enacted into law, Senate Bill 680 would enable the state to fully recover in large statewide lawsuits brought by the Attorney General for claims related to injuries to the health, safety, and the environment. We have a proposed amendment that would remove consumer protection actions from the types of claims covered by the bill. It was, I think it was in the rush of drafting. It was inserted in the bill. We didn't intend it for it to be in the bill. Senate Bill 680 would ensure that defendants pay their fair share of damages based on their actual level of culpability and not based on the total number of defendants in the action. It's important to note that Senate Bill 680 does not expand the authority of the Attorney General in the filing of any legal action, nor does it create new causes of action. But instead, Senate Bill 680 addresses how damages are allocated among multiple defendants once an action has been filed. Most other states provide for the recovery of damages in such statewide actions based on the degree of fault. Maryland, along with the District of Columbia, are the only two states that do it on much like a per capita basis, due to how the Maryland courts have interpreted the phrase pro rata in the current statute that governs the allocation of liability in tort claims involving settlements. Senate Bill 680 is narrowly tailored to change that, and only in a limited category of lawsuits that the Attorney General brings on behalf of the state for public welfare claims as defined in the bill. An example of a public welfare action that would be covered by this bill is the state's ongoing suit related to PFAS, or so-called forever chemicals that impact the health of Marylanders and contaminate natural resources. Often in public welfare actions, there are multiple defendants that have contributed to the harm and are jointly and severally liable. But there can be a significant difference between each defendant's degree of culpability. So let me illustrate, if I may, with an example involving 5 hypothetical defendants. Can we put that up on the screen? How do we put that up?
You're totally fine. There you go.
So again, let me illustrate. I'm going to use 5 hypothetical defendants. So let's say you have, and if you're looking on the left-hand side, this is the share of liability. We bring an action. The Attorney General brings a large action. We have 5 defendants, different degrees of culpability. The largest defendant has 50% of the damages could be allocated or attributable to them. We have a medium-sized defendant at 35%, and we have 3 small defendants, each at 5%, together about 15% of the damages. Under current law, if the Attorney General settles a claim against one defendant, the state's ability to collect against the remaining non-settling defendants is reduced based on the total number of defendants, regardless of fault. In a settlement, each settling defendant is assigned 1/5 of the outstanding liability, or 20%. And you see that on the right-hand side, 20%, sort of the per capita share of the fault, regardless of what your actual culpability is, which you see on the left-hand side.
If the state settles with the three small defendants for 5% each, or 15% of the total harm, the state must reduce its claim against the non-settling defendants by the full share of all three settling defendants, or 60%. The three defendants together make up 60% of the class of defendants. So I can now only settle, I can only seek recovery against the large defendants up to 40% of the total liability. This leaves the two large defendants, as I said, liable for just 40% of the state's total damages, even though the two largest defendants are responsible for 85% of the harm to the state. Under current law, the state can only recover fully from those large defendants by taking all defendants to trial. And that bogs down the court systems. It imposes significant legal expenses on the state and even greater legal expenses on small defendants. Ultimately, the residents of Maryland suffer. If the bill were enacted, liability, even in settlements, would be assigned to each defendant based on its degree of fault and relative responsibility for the harm. So in my example, if the state settled with the small defendants for a total of 15% of the liability, the Attorney General could continue to pursue the public welfare claims against the large defendants for the outstanding 85% of the state's injuries. The state's potential recovery would not be arbitrarily reduced based on the number of defendants in the case. This bill recognizes that defendants should be able to settle for their fair share of damages, and it thereby helps small and medium-sized businesses in Maryland by creating a pathway for those businesses to settle claims early and avoid the time and expense of protracted litigation. I just want to emphasize again, Mr. Chairman, Senate Bill 680 does not create new cause of action. It does not expand the Attorney General's authority, nor does it increase damages recoverable for claims allowed under existing law. The bill is simply intended to make the allocation of existing responsibility fair for small and medium businesses and for the residents of Maryland. So as the Chief Legal Officer of the state of Maryland, I request a favorable report on Senate Bill 680 to allow my office to equitably resolve cases that impact the lives of all Marylanders. Thank you, Mr. Chairman.
Good afternoon, committee members, and thank you, Mr. Vice Chair. My name is Adam Snyder. I'm one of the attorneys handling the litigation where the settlement problem the Attorney General just described has arisen. Thus far, there are two, the MTBE litigation and the PFAS litigation. In 2017, the state sued Exxon and 60 other petroleum companies to address groundwater contamination caused by the gasoline additive MTBE. It quickly became clear that Maryland's unique interpretation of pro rata obstructed settlements. In response, Attorney General Frosch in 2021 proposed legislation to address this issue by altering the statutes that govern oil control and water pollution cases. Although Mr. Frosch pointed out that the bill would apply to chemical contaminants other than MTBE, opponents of the bill framed the issue as being specific to the petroleum industry in the MTBE case. This bill has a different focus. Although it certainly would make it easier to settle with smaller defendants in the MTBE case, that case is unfolded in a way that should allow the state to settle even under current law. Instead, this bill is more about PFAS litigation and subsequent cases. In 2023, Maryland sued DuPont, 3M, and other chemical companies to recover the millions of dollars that the state has spent and will have to spend to address the harm caused by PFAS. One case has 5 defendants, the other 14. The same problem will arise in that case. And it will continue to arise whenever the state sues to address emerging environmental issues. None of us knows what those threats might be, but we know that they will come. And this issue will be there, frustrating the state's ability to take action in a fair, equitable, and efficient way. The Attorney General has a duty to bring these types of statewide cases, but he doesn't have the tools to prosecute them effectively. Other states' laws provide those tools, and there's no good reason why Maryland, the steward of the Chesapeake Bay, should not have them too. Thank you.
Good afternoon. My name is Julie Kuspa, and I'm Assistant Attorney General here in support of Senate Bill 680. When the health, safety, environment, or welfare of the residents of Maryland is threatened, the Attorney General has the ability to sue the responsible parties on behalf of all Marylanders. These lawsuits are an important tool for holding parties responsible for the damage they have caused. Unfortunately, as you've heard, Maryland is only one of 2 jurisdictions that currently uses this strict per capita interpretation of UCADA. What this bill does is allow the Attorney General to resolve cases and accept settlements from parties based on those parties' actual culpability. I want to take a moment and address some of the points you may hear from opponents of this bill. First, this bill does not create market share liability or affect the standard of liability that governs under Maryland law. Second, it does not affect contributory negligence. Third, this bill does not expand the Attorney General's ability to bring suits or to prosecute them. And finally, this bill does not make it easier to sue small defendants. The bill does not change the proof that the state must be prepared to present, the investigation and discovery that must be undertaken to prove claims, or the liability standard that will govern those claims at trial. Instead, this bill is actually about helping those smaller defendants by letting them out of the litigation without compromising the liability of the larger defendants. We heard a lot of argument back in 2021 that this bill is far too complex and filled with uncertainty. However, just the opposite is true. This bill is narrowly tailored to simply allow defendants to settle for their fair share and to bring Maryland in line with the vast majority of other states. Many other states follow the proportionate share model that is outlined in SB 680. These 30 or so other states provide a strong precedent for what we are seeking in this bill. Marylanders, just like citizens of any other state, should have the ability through their Attorney General to hold parties accountable for the harms they have caused. I urge a favorable vote on Senate Bill 680.
Mr. Vice Chair, members of the committee, good afternoon. I am Les Knapp on behalf of the Maryland Department of the Environment, testifying in support of Senate Bill 680 with the proposed sponsor amendment. It is good to be back before judicial proceedings again. I think the Attorney General and my fellow panelists did a wonderful job of walking through the bill. I just want to reiterate 3 key points. First, this bill does not broadly alter Maryland's contributory negligence system. I have been through multiple discussions on the larger issue of Maryland moving from a contributory negligence to a comparative fault system, and this bill does not do that. It is narrowly focused on a single class of cases where the state is clearly disadvantaged compared to the vast majority of our neighbors. 2, this bill does not grant any new cause of action or claim not otherwise authorized by law. And 3, this bill does allow the state to settle multi-defendant public welfare cases more effectively and efficiently. As you heard, the department is limited from being able to settle with certain plaintiffs, even where they may be inclined to settle. Senate Bill 680 would provide additional flexibility and allow MDE to better serve the interests of Maryland's residents with respect to cases like PFAS, AFFF firefighting foam, and MTBE. So for all the reasons you have heard from this panel, MDE requests a favorable report on Senate Bill 680. Thank you.
Thank you. That completes the testimony for the proponents of the bill. Senator West has a question.
Thank you, Mr. Chair. So let me first ask a question of the attorney who's handling the PFAS litigation and spoke about it. Could you move back into the podium? I'm sorry to keep asking people to move back and forth, but you're only on camera if you're at the podium. So what's the legal theory in which the PFAS litigation was filed?
There are several claims, most notably public nuisance, trespass, statutory claims, and I believe there's also a duty to warn, a failure to warn claim.
Okay, so there PFAS is the litigation is founded on the basis of Maryland current law, whether a nuisance, which is a standard form of a cause of action, or a statutory cause of action, et cetera.
That's correct.
Great. Now could I ask the Attorney General some questions? So as I read this bill, this creates a brand new form of action. It's not a tort action. It's not a nuisance action. This is called a public welfare action, which is brand new in this bill. This is not existing law. This is a brand new theory that you're putting into this bill, correct?
No, Senator,
we use the term public welfare just to essentially characterize or define the health, safety, and environment actions that the Attorney General is already authorized to bring under law, either statute, occasionally a letter from the governor, or whatever the existing authority is.
Well, that's not how I read the language says public welfare action means any civil action in which the state of the Attorney General has asserted a public welfare claim. And then the definition of public welfare claim is any claim, and we're going to, I gather, delete the consumer protection reference. So any claim arising from or related to alleged injuries to or threatened injuries to the health, safety, environment, or welfare of the residents of Maryland. It doesn't appear, this is not a tort theory. As I read this, it's public welfare action is any civil action in which you've asserted, the Attorney General has asserted a public welfare claim, which itself is arising from alleged injuries attributable to the environment or to the welfare of the people of Maryland. That appears to be entirely divorced from standard tort liability or tort claims or nuisance claims or statutory claims. Am I wrong in that?
No, so I think I'll restate that our intent is not to create a new cause of action and perhaps to address your concern. And I want to work with you and the committee, Mr. Chairman, perhaps adding something like where otherwise authorized by law, because it is clearly not our intent to create an additional cause of action. If the language creates concerns, we certainly are going to work with the committee to make sure that we are crystal clear. It's not a new cause of action, but
Right.
bring in an action that's already authorized by law. So I think maybe clarification might be necessary.
Yeah, I think it is. So let me just give the hypothetical I was going to come to next, which is that the Attorney General concludes that air pollution is primarily caused more than anything else in Maryland by automobile exhaust, and that air pollution injures the health of the people of Maryland, and therefore files a lawsuit against all the automobile manufacturers, all the state auto dealers, the auto repair shops and gas stations, all of which contribute to automobile exhaust, resulting in air pollution. And under this, that would be concluded to be a public welfare action, and you could find all those people guilty and then try to assess on a collective basis, and then to decide to apportion liability to every one of the defendants in the case. That's what I was worried about. So now you see what my concern is, and why I like your idea that we need to refine this language in order to make it clear that that kind of an action would not be authorized under this bill.
That's correct. If not already authorized under the law.
If not already authorized under the law.
That's correct.
Great. Thank you.
Sounds good. Senator James.
Thank you, Mr. Chairman, and thank you all for an excellent panel. But like Senator West, I have a couple of questions. I think everybody has, I don't know yet. So
Okay.
I think you all, I don't want to, determine who would like
I'll
to
quarterback
address
it.
it. You can, and that there was a lawyer that mentioned, rightfully so, to try to blunt opposition, that it doesn't affect contributory versus comparative negligence. Could that be elaborated on? Because that was immediately what I thought this bill would do, and or would be used in future bills to say, look, we've already started down the process in this very, important area of forever chemicals and the like. But since we're going down that road, let's expand on it. What can you all tell me in response to my concern that this would be used in that regard? And in fact, this is in sense a comparative negligence bill.
Sure. Thank you. I should start by saying that we did reach out to every sort of opponent, proponent that we could think of to ask for comments, input, suggestions to clarify. And as I responded to Senator West's question, our intent is not to disrupt the contributory negligence standard and principle in Maryland whatsoever, nor, to move to comparative negligence. So certainly we'll work with the committee to ensure where clarification needs to be made, work with the proponents, the opponents. That is not our intent to alter, change, disrupt that regime that exists in Maryland.
So maybe what we would do, and I'm not is some language to make sure that anybody who reads this law would understand that this is not intended to change that scheme, just to be very, forthright about it and clear. The other question I have is probably for a prior speaker, and who indicated that in one of the Forever Chemical cases, what he indicated was that they were able to do a workaround just because this bill is going to be prospective. So even if there are any current Forever Chemical type litigation going on right now, we're not making this retroactive, only prospective. Is that correct? This is a prospective bill, right?
Yes, it applies prospectively to only settlements entered into after its effective date.
Oh, so if you have a current case though, and you're working on a settlement and you haven't finalized that settlement, this would apply to some pending litigation.
It would.
Okay. I think you indicated, I'm sorry, what was your name again?
Adam Snyder.
Adam Snyder. Mr. Snyder, did you indicate that you were able to do a workaround to come to a resolution, I guess, that satisfied the interest that the most culpable defendants are, paying one thing and less culpable defendants are paying another? Or could you just elaborate a little bit about the workaround that you had? And why am I asking? I'm wondering, is the bill necessary? Obviously, it's always the test. And then, so it would be like, what were you able to work out even under our current structure?
Well, we haven't been able to work out anything yet. We have a plan to work it out.
Okay.
And the workaround works there because it's in the MTB case, and it's just the.
What is MTB?
Oh,
is it like a long chemical name?
It is
No worry
very
about it
long.
then. Just wanted to know if it was.
It's a gasoline additive. That's
Okay,
all.
that's fine.
You have kind of two groups of defendants there. You have manufacturers who kind of supply MTB gasoline into a pipeline, so you can't tell whose gasoline is which. And then you
Yes,
have
I
tank
see that.
owners
Right.
whose liability is very specific. So
Right.
because of that difference in the two groups' liability, they're not all going to be jointly and severally liable for the entirety of the state's injury, which alters the way UCATA, which is the statute that we're talking about here, would apply. So we think we have a way to fix it through that mechanism, but make no mistake. And this bill would make it easier for us to settle with these small defendants.
And, I am a trial lawyer and I have done some very complex cases, not in this area. But having said that, what's been my common experience, I'm usually on the defense side, is that defendants sort of also know who the more culpable parties are themselves, right? So, through indemnification and all kinds of side litigation, if you will, between each other, they often come up anyway with, all right, this smaller defendant's going to put in 5 million, this heavy hitter's 100 million, and so forth. So in a way, I don't think you would disagree with me that is often how cases with multiple defendants, especially, in this area, might work out. So I guess I'm lost in how that system is not working currently. So could you just, I hear you telling me, it makes it difficult for settlement, but I've been in a lot of big cases with a lot of complex settlements, and usually the defendants figure out and prorate amongst themselves on how they're going to pay up in a case like this. So if I'm wrong, and maybe it's unique to this kind of Forever Chemical, I don't know.
Well, in the MTBE case, we're talking about 62 defendants. And if you look at how those cases have unfolded in other states,
right,
there isn't this, let's get all of the defendants together and settle this in one fell swoop. Some will settle early, others are going to fight to trial.
Right.
And that's the way they've unfolded. So there are, as you say, sometimes complex litigation will be resolved that way. The track record in the MTB context, that's not been the case just by the proclivities of the defendants that involved. Some of them want to go to trial, some of them don't. PFAS, it's a little bit harder to tell because that is such an emerging area.
And what does that mean? What is that?
Okay,
it's another chemical.
It's another-
All right, we're talking about.
Forever chemicals.
Okay.
These are.
So I'm wondering then if it's Forever Chemicals that seems to be the issue, would we not want to narrowly tailor the law to address that and a particular arena? And then if there are other areas, you could always come back. Just because we're opening up and doing something very different. I understand we're in the minority, but we're also in the minority for comparative versus contributory negligence, right? So I'm just wondering if it's the nature of this litigation, or can you give me a lot of examples of other litigation for which this unique problem of chemicals and forever chemicals? Are there other cases you can think of in other areas?
Yeah, I mean, the only ones that we're familiar with is PFAS, and a lot of states has filed those suits. It's hard to tell what the next thing is going to be. We might not even know what that chemical is now.
No, I get the chemical. I'm trying to figure out whether we should narrowly tailor this to these environmental type cases. If we could do a better job at crafting this bill, you don't have to answer now,
Yeah.
just thinking about it out loud. A better job of crafting the legislation, giving us a measure of comfort that we are doing something in an area that we understand because you all have explained it to us, rather than just opening it up, unless you all can come back and show us multiple examples. So
Yeah, well,
I would say
think
get back to us on that.
Sure. we'd be
Thank
happy
you,
to do
Mr.
that.
Chairman.
Thank you, Mr. Chair, and sorry for taking a second bite at this apple, but another question arose. So, Mr. Attorney General, could you just step up there and confirm that there's no intent in this bill to eliminate the requirement of establishing proximate cause in terms of establishing liability?
That is correct. I mean, this bill does not alter, standards around causation in any type of action. Formulas and standards for establishing damages, in its total. Certainly no new cause of action. And again, to the extent that we need to work with the committee to make that crystal clear, then we will do that. I want to say that if I could pick up on a response that Mr. Snyder mentioned when he said easier, I'm always fearful when I hear that, because I don't want you to think that your attorney general is coming here saying, make my job easier, right? These are tough cases, and they're tough on the culpability liability side. They're tough on the damages side. By easy, really what it means, it is for those smaller defendants. Say, hey, I want out of this. I want out of it. I don't want to be one of the 60. Okay. My culpability is small. I want to be able to settle and get out of this and go on with my business. Okay. Doesn't change the cause of action, doesn't change the total damages I'm going to recover, but it's going to give me the ability to say, okay, easy, small, you're out. You want to be out, you're out. And I don't lose a large share of my damages for the culpability of those that want to go to trial. Now, I'm not suggesting that, if you go to trial, you're going to be penalized. Absolutely not. If you go to trial, okay, and the state wants to get the 85% of your culpability, the only way I can do it is if I bring in all the small businesses as well to trial. So that's what we meant by easier for a lot of folks that want to get out of the case, settle out of the case, and let us focus on where the bigger damage has been done with parties that don't want to settle.
Great. I think your answer is very helpful. As I first read this bill over the weekend, I understood it to be an attempt to try to get around the problems of the Maryland Uniform Contribution Among Joint Tortfeasors Act, which is very complicated and very difficult to apply in specific circumstances. But then as I read the language, it seemed to be broader in scope than just that. But it sounds from your answer as if what we're really talking about is this Joint Tortfeasors Act and its limitations on your situation in cases like PFAS, trying to settle with small defendants who just want out, but complying with that particular statute, the Joint Tortfeasors Act, creates a world of complexity, which you just want to get away from.
Yes, and what I should add, the reason why we didn't go into UCATA itself to amend it, because we heard from the business community, like folks are accustomed to the practice, right? They've got the decades worth of experience in litigation, on liability, on damages, and the idea of disrupting UCATA for all of Maryland, that was a little too much. So we said, okay, let's put it in the state government article, only applies to actions brought by the Attorney General, and working with you, we will be very clear on what those actions are.
Terrific. Thank you.
Excellent. Additional questions from the committee? All right, seeing none. Thank you all very much. Thank you. That'll conclude the testimony for the proponents of the bill. We'll now switch to the opposition panel. And we'll hear from Mr. Philip Goldberg, Mr. Enton, and Mr. Kirk McCauley.
Good afternoon, Mr. Chairman, members of the committee. My name is Phil Goldberg, and I'm a resident of Montgomery County, been since 1998, and a partner at the law firm of Shook, Hardy and Bacon. I'm testifying today on behalf of the American Tort Reform Association, which is a broad-based coalition of businesses, municipalities, associations, and professional firms that promote fairness, balance, and predictability in civil litigation. As written, SB 680 gives the Attorney General unprecedented authority to sue individuals and companies that do business in the state. And I understand we heard a lot from the Attorney General and his staff about how they would be willing to amend the bill. But I'm talking, my testimony is about how the bill is actually written. As you know, the state constitution empowers the Attorney General to investigate, commence, and prosecute civil actions in which the state may be interested as directed by the General Assembly. This bill, in one fell swoop, would grant the Attorney General open-ended authority to sue whomever for whatever. It invents this public welfare action where the Attorney General can unilaterally decide what is or is not in the public welfare, and to bring a civil enforcement action against any person or entity the Attorney General decides should have to pay the state. This authority is unparalleled in scope and power and abandons bedrock legal principles, including fault, causation, and notice of wrongdoing. Specifically, under this bill, a person or entity would no longer have to wrongfully cause an alleged public welfare injury for which it is sued. Instead, the bill directs the fact finder to determine total liability for the alleged public welfare condition without providing any criteria for defining what that liability entails, how it is determined, or how the damages the state collects from the lawsuit would be spent. Next, it gives the fact finder the authority to apportion those damages among whoever the AG decides to sue, again, with no guidance for how to do so. Instead, it invokes a concept of comparative responsibility that is not the law in any state. And the fact finder can make one person or entity pay for the entire public welfare problem if equity requires, but again, does not define when this would be appropriate. In these lawsuits, it would be irrelevant if the defendant did nothing to unlawfully cause the situation at issue, that other people or businesses are actually responsible, or if nobody is at fault. The Attorney General could still decide to sue people and entities over the alleged public welfare condition and make them pay money to the state.
Thank you very much, Mr. Goldberg.
Thank you.
Thank you.
Mr. Chairman, members of the committee, Robert Enton, testifying today against this bill on behalf of the Maryland Bankers Association and the American Property Casualty Insurers Association. You have the written testimony of the American Property Casualty Insurance Association, and I would urge you to read that testimony. And I know you get 10 tons of written testimony, but if you're seriously considering passing this bill, I would urge you to read it. To my knowledge, no state in the country has this type of statute. When you look at the definition of public welfare claim, even taking out the reference to the Consumer Protection Division, it says it arises, any claim arising from or related to alleged injuries to or threatened injuries, maybe there is no injury, say threatened injuries to the health, safety, environment, or welfare of the residents of Maryland. And what it does is it totally does away with the current law on how fault is apportioned, and instead leaves it up to the Attorney General in his sole discretion to decide how to apportion fault. Up to his sole discretion, with no limitations whatsoever, and it's in every single type of claim. So is it a claim against multiple insurance companies? That multiple insurance companies has some violated the law, against hospitals, against banks, you name it. They're all dragged into this. And once again, you take the discretion away that's existed for decades and decades under Maryland law and leave it solely within the discretion of the Attorney General. All the testimony has been about environmental issues. But this bill never specifies that in any way, shape, or form. It's totally broad. It can cover any kind of claim. Once again, I would urge you to read the written testimony from the American Property Casualty Insurers Association. And I will close by saying that the Attorney General's office did reach out to a number of stakeholders, but then the meeting was canceled and we never heard any more about it. So we've not had any input into this whatsoever. Thank you. Happy to answer any questions.
We'll take questions at the end of the panel. All right, thanks. Thank you.
Members of Chairman, Vice Chair, members of committee. My name is Kurt McCauley. I represent WMDA Car. We represent service stations, convenience stores, and automotive repair shops in the state of Maryland. You have my written testimony, so I'll be very short. This bill casts a net so wide, it would take two boats to pull it. It just grabs hold of everything. Technically speaking, the way the bill's written, that I understand, I'm not a lawyer, but if you gas your car with a fossil fuel and you know fossil fuel is causing emissions, you could be charged. You could be in that net. I know that's radical, and I don't think that's the Attorney General's thought, but it's a bad bill. It just puts so much out there that they can grab hold of. And the way it's written, it's just not good for small business at all. Thank you.
Thank you very much. All right, we'll switch over to questions. Senator James, then Senator West.
Thank you, Mr. Chairman. You all heard some of my questions posed to the supporters of the bill. So what I'm hearing for the first time on this side is that there's no state in the nation that has this language of public welfare action and what a public welfare claim is. Now, I probably misunderstood the supporters. I thought they said we're one of two that are hanging out there without this kind of legislation. So which is it? Is it that or are you guys talking past each other? They're making some other claim about the bill.
So the way I read the bill as written is that it assigns something called comparative responsibility. That again is not the law in any state. That you can be assigned your relative degree of responsibility without any factors, abandoning proximate causation as we heard before. And who's to say what that is, right? So if you have, if we saw the slide before about actual culpability, how is actual culpability decided? Here, it could be anything, and there's no guidance whatsoever. That is not the law in any state. You have to follow proximate cause. You can only be responsible to the harm that you actually caused. And this provision in lines 25 through 29 basically leave it up to the fact finder to make any decision on responsibility that they want.
Well, I guess I have a map here. I don't know if you all saw this map. And it says, they're trying to say that Maryland, we have the per capita pro rata, which we know we do. And I guess they're giving me an indication that lots of other states have this proportionate, equitable, relative share. So I'm just trying to clarify, and you all can get back to me, that even with that designation, proportionate, equitable, relative share, that is not the same as what is in this bill as drafted currently. Is that
that is my understanding?
Okay.
As I've read it, and as a bunch of people that I know have read the bill and tried to understand, frankly, it was a little challenging trying to even understand what this bill is trying to do. I understand from the testimony before and from the fiscal note that it was supposed to be narrowly tailored to the situations that we heard, but that's not how the bill is written and how it could be applied in the future if it were passed in its current form. There's nowhere in this bill that mentions pro rata share, that it's trying to take on that specific problem. I appreciate the offers of clarity on making sure this doesn't get rid of proximate cause, making sure this isn't undoing contributory negligence. If there is a problem that needs to be resolved, I would hope it would be narrowly tailored to that problem, but that's not what this bill is. As those of us who read these kinds of things, as we all read this.
Yes, well, you saw at least two of us suggesting all kinds of narrowing and tailoring if we were to even to consider it. So I guess what I would ask you all lastly is let's say I'm in you have a national perspective, do you not?
To some
No,
degree.
okay, well, so in a state that has a proportionate, equitable, or relative share concept, how does it normally work when you have multiple defendants?
So I can't speak to the situation that they were talking about in terms of the specific environmental issues cases, because that's not my area. of
You
expertise.
don't have to be in the
But if you're-
environmental world because
Yeah,
I
if
hear
you're
you.
talking about generally how, there are some states that do comparative fault, that do pure comparative fault, that do, if you're more than 50%, then there's certain rules that apply to you. Maryland has always been a contributory negligence state, has never dipped its toe down that path. This would essentially take all that away for these attorney general actions and say that they could just divide out how they.
But I guess what I'm asking is in those states that do have something like a proportion or equitable, are there standards that exist?
That I don't know the specific cases that they're bringing. I'm happy to
Yeah,
work with you
I
on
think
that
you
and
should
kind of drill down.
come back to me and tell me, because we were led to believe, or it was my impression, that we would be aligning ourselves with other states. But if in fact that's not what we're doing, because other states, even if they have comparative or proportionate liability, have lots of standards around how that's done, and that it's not in the sole discretion of the state of Maryland to decide that there's some relationship between the defendants. And as my own personal experience, oftentimes defendants look themselves at the facts and have lots of side agreements, up and down, involving indemnification and hold harmless and all kinds of other provisions, that none of that would be applicable here, because apparently the attorney general would decide, not whatever the private litigants have decided.
Right.
So if you can get back to us to either confirm what I've just suggested or let me know where I'm misunderstanding what other states are doing, that would be helpful.
Absolutely.
Yeah, I would only say, Senator, that I think, you've hit on one of the main issues that this puts it all within, and I have a tremendous amount of respect for Attorney General Brown. I've known him for decades. But this puts it all within the discretion of the Attorney General. It's not changing the tort system or the liability system for what a court would decide, or what a judge or jury would decide.
Which
it
is
puts it
normally
all
what
within-
they do, right?
Right.
Right. Normally the court and the jury system will look at and
Right.
decide these matters.
But
Exactly.
it changes the underlying Maryland bill on comparative fault and joint and several liability, and leaves it totally up to the discretion of the Attorney General to decide. And there's no limitation. That language doesn't limit it to anything.
Thank you very much. Thank you, Mr. Chairman.
Thank you, Mr. Chairman. Obviously, this bill needs a lot of work in terms of its language. If there is an appetite on the part of this committee to work on this bill, are the three of you willing to assist us in that enterprise?
Absolutely.
And then my last question is, after I got through reading over the weekend, the very complicated language of the bill, and I agree, it was hard to figure out what the bill was about. But once I got past that, it appeared as if at the bottom of this, there was an attempt to deal with the joint tortfeasor problem here in Maryland with these PFAS cases, toxic torts, that sort of thing. Would you all have a problem in making modifications to the Maryland system, the joint tortfeasors, in conjunction with the Attorney General to deal with this particular situation?
I would just say, Senator West, that we'd have to, the devil's in the details.
Of course.
And, this has been Maryland law for decades and decades and decades. And this is what we've all dealt with from a liability point of view. And if you're going to abandon that, then the question is, how do you do that? Why do you abandon it? What's the new law going to be? What does it apply to? And we've not heard, I think, any testimony that our overall tort system is broken and needs to be changed.
Well, all through my years of practicing law, fortunately, I've never had to deal with the tortfeasor laws. And every time I've approached them, I've backed off, saying to myself, oh my goodness, this stuff is really complicated. And so I can see why the Attorney General would feel frustrated trying to deal with these tortfeasor laws in this new area of toxic torques and PFAS and things like that. So my understanding is he wants to try to have legislation which would not require him to go through all the ins and outs of our joint tortfeasor system, And I would be willing to work with him on that issue. What I'm concerned about, this bill goes way beyond, seems to go way beyond that and creates an entire new, as you could tell from my questions earlier, the Attorney General, entirely new cause of action theory, which I'm not prepared to deal with.
Yeah. If I could, Senator West, I would just say this, that listening to the testimony, reading the fiscal note, it just seems to me that, it's up to the Attorney General. If there are, 4 potential defendants in this case, and if, nothing stops him from going after the one big defendant that he thinks he needs to go after. I'll settle, with this one for 5% for this small amount and this one for this small amount. To get them out of the case. He didn't need to bring the case against him in the first place.
Mr. Enton, it sounds so simple, but settling with one for a small amount could have negative repercussions on the rest of the case. And that's what the Attorney General, I think, is trying to fight his way through.
Yeah, we're happy
figure
to
out how to deal with this.
We're happy to sit down with Attorney General and the committee and try to come up with a reasonable way to address his concern. But I just think that this bill doesn't get there.
Thanks for your answers.
All right, seeing no further questions from the committee, thank you all very much.
Thank you.
Thank you. That will conclude the hearing for Senate Bill 680. We'll now move on to Senator Washington, Senate Bill 518. Senator Washington, welcome back.
Thank you, Mr. Chairman and members of the committee. For the record, Senator Alonzo Washington here to speak on SB 518, Task Force on Property Appraisal and Valuation Equity. I'm going to be very quick on this bill because it is just a sunset extension of the current task force. And I'm being short because I would like for you all to move this bill very fast. But it is just a sunset extension on a bill that we all know that it's really important to making sure that discriminatory practices that exist in property appraisals and valuation are completely, we study the issue. DHCD supports it. There's other folks that support it too. All the members of it support it. They just didn't have enough time to complete their work and asking for an extension. Thank you, Mr. Chairman.
Excellent. Thank you very much, Senator. And I think you have one witness signed up in favor virtually. She just joined in. Yep. Ms. Cross, welcome. Good afternoon, Ms. Cross. We are ready for your testimony. You can take yourself off mute. We're ready for you. Ms. Cross, can you hear us?
Yes, I have you now. And could you please introduce the title and the number of the bill on discussion? Just for the record, when we're out in the holding room, nothing shows up for us, so we cannot see what you see. We're in the dark.
Excellent. Pro tip in the future, you can watch this, you can stream the hearing on YouTube or the MGA website. If you just mute that, then you'll be able to see kind of where we are in the hearing. So Madam Mayor, you're up. This is Task Force on Property Appraisal and Valuation Equity Alterations, Senate Bill 518, sponsored by Senator Alonzo Washington.
Okay, thank you so much. Testifying on behalf of Senate Bill 518, Task Force on Property Appraisal and Valuation Equities. I am in favor of this bill. I do note that as we look at many of the property appraisals, particularly in a city like mine, in the city of Glenarden, where we are still 80+%, that the appraisal rates do not equitably match across the demographics. We do have a new rising community, Whitmore Town Center at Glenarden, at which this bill brings more valuable interest in my life, because we are rapidly rising when it comes down to the property appraisal of the Whitmore Town Center homes there. Many of which have gone from $524,000 to up to almost $900,000. So an adequate appraisal, as you can see, is the difference between, a successful sale, particularly in a market that has been coupled with multiple growth opportunities in and around our borders. we do agree with the termination of this task force, but I also put that we do need to ensure that in this extension period that we're adequately taking a smart sampling across as I sit in Prince George's County, but also all counties, to ensure that as we move forward with diversity, equity, and inclusion, that the appraisals that come back particularly are matching not just the area of the demographics that's there, but the total sum of the zoning in which the particular county that is being evaluated is equally matched, regardless of ethnicity of those that reside in the homes. But I do thank you for bringing this bill, highlight its effective date and soon.
Excellent. Thank you very much. Seeing no questions from the committee, that will conclude the hearing for Senate Bill 518. Thank you very much, Senator Washington.
Thank you, Mayor.
Excellent. All right. With that, we're going to move on. Is Senator Benson here? Senator McKay, are you ready to go? All right. It's a good Navy term, always ready. All right, Senator McKay with Senate Bill 785.
Mr. Chairman, empty chair, Mr. Vice Chair, and members of the committee. Senator Mike McKay on behalf of Senate Bill 785. So I strongly endorse Senate Bill 785. This bill will prohibit any common carrier from damaging a bridge or a highway that is owned or controlled by the state, a county, or a municipality, resulting in a closure. If the carrier does not violate the act, it will authorize the Attorney General, the state's attorney, and the abiding to bring civil action against the carrier for violating the law. Well, let me tell you about a little story. So in Cumberland, I live in the historical district of Washington Street. Washington Street is known for its very, very large, stately homes. The house that I live in is 10,000 square feet. We have a bunch of apartments. But there are a variety of homes that people like to come and visit and send buses up and down to come visit for tourism, to see the stately homes. Well, unfortunately, back in 2016, the bridge was closed to vehicle traffic. And there was an inspection that was found on the bridge for its deficiencies. And CSX made basic repairs to the bridge, and it was reopened to one-lane traffic in October of that year, 2016. However, the bridge suffered some stress. CSX actually hit the bridge in 2017 and 2018, and the bridge was then closed after August of 2007, again being strict, and has been closed ever since. So this is a bridge that has been closed since 2017. Now, there's a variety of reasons. There's been talk of lawsuits. There's been talk of ownership. And the bridge still remains closed. CSX has no real interest in replacing the bridge. Actually, I think they would actually favor just removing the bridge. The ownership of the bridge is in play. But again, since 2017, we've not been able to cross this bridge. Why is it important? There are 3 bridges that get over to the west side of Cumberland. So when it comes to public safety, fire trucks, those type of things, it makes it a little bit hard. Now, I will tell you, I can open up the windows in my house because there's not any vehicle traffic because no one's going across that bridge. And for many, many years in the House of Delegates, and even last year as a senator, I never brought up this issue just because it's a personal issue of mine and trying to keep quiet. But Delegate Buckle in the House of Delegates has decided to go crazy over this. And I cross-filed this bill for him. So, you know, at the end of the day,
if you had a bridge in your community that had been closed for more than 10 years, that the county, the municipality, the state, all have tried to do something, but have not been able to do anything, you would provide that as a public nuisance. And so we're asking for a favorable report on this bill to actually get some form of push behind the Attorney General or the state's attorney to bring civil action against a carrier who violates the laws. And you've heard of a bridge to nowhere. We can't even connect those two places without the bridge. So I urge a favorable report on Senate Bill 785, and be glad to answer any questions you may have.
Senator, thank you very much for sharing that. That's fascinating. Questions from the committee? Senator Sidnor.
Just, I guess I'm confused. If they damage something, your local state's attorney or county attorney, they aren't able to sue?
So the issue is that the ownership of the bridge. So if CSX owns the bridge, what they hit, they'd have the right to actually take it down. The city and the county don't want that. I will tell you that if you replace it with federal dollars, you'll actually have to take out 2 or 3 of the homes that are along the historic district, because it would create walls, and you actually would enter in front of my house, which is 2 houses up from the bridge. You would enter onto the new bridge so that you could see the ongoing traffic. So to answer your question, I wish it was as easy as the state's attorney to do that. But it makes it really, really tough. And at some point, inaction, and that's what we've been dealing with, not because not everybody wants to do something, they just can't. And so we're looking this as a possible tool to encourage CSX to come up with an idea.
Thank you.
Thank you, Mr. Chair. I'm glad you brought this bill forward. I know I do a monthly meeting with MDOT every single month, and our DPWT. And one of the things that came forward was saying another issue with CSX, and I've been working with their lobbyists to come to some understanding of some pathways forward to address some of the issues, because we have a crossing that a lot of folks are concerned about, and it's taking a long time to get some traction on it. So I think we're moving forward, but if we don't have any remedy, I think this is a good bill to hold large corporations accountable to taking care of responsibilities in our community that they use or that they damage. And so it's good to hear this bill and know that something like this is underway. I'm hoping CSX works with you guys the same way they're working with us to come to a resolution with the problem that we're having. And I'm hoping they hear this loud and clear as something that we all are taking very serious about having a conversation and fixing these problems.
Well, thank you. Thank you for the question there, Senator. Look, in no way is this to do any kind of disparaging upon CSX on my part. I think that everybody has tried to do what they can, but unfortunately, there really isn't a good answer. But as I said earlier, no action is not the answer. And so if we can reignite the conversations, it'll be a whole lot better. And, the good thing about this bill is it doesn't involve paint.
Or condo solar.
That was too close.
Yeah, too close to too soon. Actually, my dad grew up. He lived on Washington Street. So I know we were going to talk about this when I came to visit, but I'm familiar with the area. So my dad was born in Cumberland and over there. So it's kind of a cool area. I was going to, but I got sick. I couldn't make it. All right.
Thank you, committee.
Thank you. All right. That will then conclude the hearing for. Oh, I'm sorry. We have one more witness joining us virtually, the mayor from Glenarden. Welcome back. If you could take yourself off mute, Madam Mayor. And I'm going to give it to you how you like it. So we've got, this is Senate Bill 785, public nuisance, common carriers, damage to public infrastructure. And that's sponsored by Senator McKay. Welcome back.
Thank you so much. And I do favorably support this. Common carriers have a responsibility all to protect not only our communities, but also to do the common service that they are hired to do. With that then becomes a level of responsibility when it pertains to our infrastructure. If you talk about bridges being damaged, we have noted many times in America's most recent history how damaged bridges lead to catastrophic affairs and events relative to our citizens with trust on our highways and byways, unfortunately finding themselves in a precarious predicament because of something as simple as a bridge being hit. I'm grateful for this bill coming forward, that we maintain our state and county necessities, referencing the infrastructure. As we find ourselves, we're not a young county in Prince George's County or any other counties really. What we do have is a persistent, consistent update and maintenance, and common carriers have to have that responsibility. I would like to say that they have an insurance policy that maybe we should put some cameras therefore on those areas that have a persistent hit rate by common carriers, either driving too fast or unwieldy. But I thank you so much for bringing this and also being able to bring civil action against that common carrier for violating these acts. I think is an exceptional piece to put into this bill. And thank you so much for your consideration for the safety of all citizens who trust these roads and byways every single day. In favor for Senate Bill 0785.
Excellent. Thank you very much. Seeing no questions from the committee, that will then conclude the hearing for Senate Bill 785. Thank you. All right, we'll now move on to Senator Benson. Welcome back. Senate Bill 725. Senator Benson, would you like to bring up your, well, actually, sorry, we're favorable with amendments. So we'll hear from the senator and then we'll have the next panel.
Thank you very much, Mr. Chairman. Good afternoon, Mr. Chairman, Mr. Vice Chair, members of this esteemed committee. It is an honor for me to be here this afternoon once again. I'm here to ask for your favorable report on Senate Bill 225, requiring renters insurance. And I'm going to talk about that requiring word in just a few moments, because we do have an amendment that speaks to that. Renters insurance stands as a critical safeguard, offering coverage for personal belongings and property within the dwelling. It further extends to cover additional living expenses in the event of disasters like fires or water damage. Despite its clear advantages, it's a considerable portion of Maryland renters remain unprotected, lacking the essential insurance. This bill seeks to close the coverage gap, ensuring that many more of our residents are shielded from the devastating financial impacts of unexpected catastrophes. With the cost of renters insurance averaging $191 annually in Maryland, it is a financial accessible means of securing one's financial well-being. Throughout my tenure, I have encountered numerous instances where individuals, through no fault of their own, have been rendered homelessness following disasters. These situations often arise from property owners' refusal to provide financial assistance, leaving tenants in dire straits. In such cases, the only resource has been to seek temporary shelter for these individuals through personal favors or limited aid from organizations like the Red Cross, which can offer little more than the normal support. The impact is even more severe for those who find themselves indebted to landlords, as evidenced by the tragic gas explosion that led to the destruction of 2 buildings in Montgomery County. And we just heard about one that just occurred in the great state of Virginia. The need for legislation is made more urgent by Maryland's current state of insurance coverage. With only 67.8% of homes owned by the occupants being insured, a significant number of renters are left vulnerable. Mandating renters insurance would only secure tenants' belongings, but also protect responsible rental practices, thereby enhancing the stability of our rental communities. Additionally, this bill aims to reduce the legal and administrative complications frequently associated with property damage in rental properties. This legislation marks a pivotal move toward improving the safety and welfare of Maryland's renting population. It reflects our collective commitment to ensure the protection and responsible tenancy of our residents. By requiring, and I'll speak to that in a few moments, all renters to have comprehensive insurance company coverage, we are taking a significant step toward creating a more secure and stable housing environment. Let me repeat that. By requiring all renters to have comprehensive insurance coverage, we are taking a significant step toward creating a more secure and stable housing environment. Now, we are asking that you consider an amendment to this bill. We have consulted with interested parties and proposed some changes in addressing their concerns. We heard the number of people who came to our office to talk to us about this bill. We are very concerned, and we decided that we better take a second look at this bill and to make some different approaches to the bill. Tenants must provide the landlord with an active declaration page of their renter's insurance policy at the time of signing a lease and a lease renewal. But if the tenants are facing financial hardship, they can submit a request for a renter's insurance waiver to the landlord when initiating or renewing their lease. It is important to note that non-purchase of renter's insurance should not be considered a breach of contract and should not lead to an eviction. At this time, I'm asking you to please give a favorable response to Senate Bill 725.
Excellent. Thank you very much, Senator. Questions for the senator? All right, seeing none, thank you very much. We're going to switch to the panel behind you, which is favorable with amendments.
Thank you.
Thank you. We will hear from Ryan Washington, William Castelli, Grayson Wiggins, and Ms. Cross is going to be joining us virtually momentarily.
Thank you, Mr. Chair. And for the record, my name is Ryan Washington with the Apartment Office Building Association. We appreciate the bill sponsor for bringing this bill forward to the committee. We worked with the House sponsor previously. We do have significant concerns on the bill, but they have been addressed with some of the amendments, and we look forward to amending the Senate bill version. And I'll stay for any questions. Thank you.
Good afternoon, Mr. Chair, members of the committee. Grayson Wiggins here on behalf of the Maryland Multi-Housing Association. We do have some concerns with the legislation It's good to hear that the requirement that a landlord would be, the provision that would require a landlord to obtain renter's insurance if a tenant failed to comply is being amended out of the bill. But we do have some remaining concerns regarding page 3, lines 27 through 33 that prohibit a landlord from placing any requirement on renter's insurance. I believe there are also some concerns from organizations like the Attorney General's office about the cost here. And so we'd be happy to continue to work on this bill with the committee moving forward if that's the way we want to go. And I would just also note that on page 3, lines 27 through 33, there's a reference to renter's insurance, whereas on page 2, there's a reference to renter's insurance for personal property. So I'm not sure if that was a drafting mistake or what, but that's something that the committee should look at as well. Thank you.
Thank you very much, Mr. Wiggins. Questions from the committee? All right, seeing none, thank you very much. We'll now be joined by our final witness on this panel, Ms. Cross. Madam Mayor, welcome back. This is
Thank you
Senate
so
Bill.
much.
Welcome.
Senate Bill 725. Favorable with amendments, I do acknowledge that there was a from property to personal property. However, having been a renter manager of 2 properties myself over my military career history, I will tell you that renter's insurance is a critical need. So I am grateful to Senator Benson for bringing this forward, particularly in this time where we have a lot of folks, particularly the military people who move from locations, but have chosen to make Maryland home. So they go away, but they rent these homes and then they allow themselves to continue to be protected by the requirement to have renter's insurance. I know that LegalZoom and other types of legal preparational tools are out there for landlords, but also for the renters themselves. Everyone should have personal property insurance because you cannot be for sure of what your property will cost in today's market. It's just a nice requirement. No, it is an absolute requirement. So I thank you for bringing that even in the bill, even if it was a mistake, that would be an amendment I would recommend adding. I do favor with the amendments to add personal property because one thing's for sure, if something happens in a rental location, somehow that personal property is going to be 100,000 plus. We cannot bankrupt homeowners and we cannot bankrupt those that are trying to provide affordable, adequate housing in a very tight market, particularly following COVID-19. Favorable with amendments, Senate Bill 725. Thank you.
All right, thank you very much, Madam Mayor. Questions from the committee? All right, seeing none, that'll end the hearing for Senate Bill 725. Thank you very much, Senator. Excellent. We'll now hear from Vice Chair Walstreicher with Senate Bill 743.
Thank you, Mr. Chairman, members of the committee. As my panel gets settled here, this bill has to do with stalking and how that can fall in a hole within our protective order and peace order scheme that we have in the state of Maryland. So many of you know from being on this committee or sitting on the Judiciary Committee before us that the protective order is traditionally used for intimate relationships or family relationships, some type of close relationship, and it has its own benefits that come with that. Included in that is the length of the protective order, and a path to permanency in the protective order. And also because people are living sometimes in the same place or close together, the protective order has protections when it comes to the removal of weapons from the home. The peace order is separate. The peace order is for neighbor disputes. So you get in a fight with your neighbor over, cutting the grass, and then so you wouldn't be eligible for a protective order. You're not in an intimate relationship. You go for a peace order that has some fewer protections because it's not an intimate relationship. Stalking is a challenging crime to fall into one of these two categories. 40% of stalking is intimate partner stalking, meaning someone with whom you previously had an intimate relationship. But 60% of stalking is from strangers. complete strangers. But the nature of stalking more closely aligns with some of the things that we have in the protective order. In other words, they're strangers, just like a peace order would indicate. But the nature of the stalking, getting messages and getting pictures and having people show up at your home and texting you, has more of the intimacy, even though there's no sexual relationship, of the protective order. And so what we're trying to do in this bill is find a place to put the stalking protective status in a way that works with both the peace order and the protective order. So how does this work? What we would do would be to extend to stalking some of the benefits that you get in the protective order. You would start with a longer length of the protective order. There would be a path to permanency in that protective order. And you would have the ability to remove weapons because of the danger of weapons when it comes to stalking. The way the bill came in, it essentially puts stalking into the protective order. It's not particularly relevant to me where the protections go, just that we have these protections. And the consensus among the advocates that we've been discussing is that it's more appropriately placed in the peace order. And so there will be a sponsor amendment that essentially takes our bill and puts it over on the peace order side. Again, the structure is less relevant than that we provide these protections to stalking victims. And you'll hear from one who has a very serious case. And in fact, if she'll go next. With that, Mr. Chairman, I would ask for a favorable report.
She can go next.
Okay.
Good afternoon, Chair Smith and members of the committee. Thank you for the opportunity to provide information relevant to SB 743. My name is Margot Lee Williams, and I am president of the Board of Directors of Just Stalking Maryland Resources and a parent of a stalking victim of 15 years. Senate Bill 743 is predicated on the premise that the alleged perpetrator will not only be convicted of stalking, but receive the maximum 5-year penalty and have served at least one of those years. In fact, only about 12% of all cases are prosecuted. Of that 12%, only 6.5% result in conviction. And of that 6.5%, only 4.1% result in jail time. So if only 6.5% of stalking cases end in conviction and only 4.1 serve jail time, how will this bill help the other 96% of stalking victims whose alleged stalkers may have been convicted for different crimes associated with the stalking, but weren't convicted of the stalking? The problem may be in the limitation of the Maryland state stalking law to very narrow definitions of intent, reasonable, and fear of serious bodily injury or death. Apparently, though, other concerned or anxious victims aren't being heard. For instance, with intimacy-seeking acquaintance stalkers with no history of intimate or domestic relationship, the danger of physical harm to the primary victim is small, only about 5.4%. But the persistence is significant, with 32% lasting past 1 year, even decades. According to the 2019 National Stalking Victimization Survey, victims of both traditional and electronic stalking are actually more fearful of someone close to them being harmed, or losing their jobs, or losing their social networks, peers, friends, or freedom, of the behaviors never stopping, not knowing what would happen next, or losing their mind. These are all fears which could be mitigated by a long-term protective order or even permanent order. Thank you.
Chair Smith and members of the committee, thank you for the opportunity to provide information relevant to SB 743. My name is Turquoise Williams, and I'm the Executive Director of Just Stalking Maryland Resources and a stalking victim for 15 years. We want to highlight some of the barriers and gaps in the proposed legislation. It does not specifically provide for nor outline a pathway to obtain a permanent relief needed to those experiencing persistent or recurrent stalking. Acquaintance stalkers are 42% more likely to persist longer than 1 year, with findings as great as 40 to 80 years. Recurrent stalking victims are 38% more likely to recur. Upgrading to a permanent order is still upgrading to a permanent order may still require meeting eligibility based on intimacy or shared residence. Over 50% of us stalking victims changed our jobs or retired early. Lifetime's costs are approximately $140,000 for women and $23,000 for men. The added cost of a peace order, including $46 for court fees and $40 for service fees, despite using ourselves as bait and involving friends 4 states away, whereas protective orders are free, is left unaddressed. As a victim of an acquaintance stalker, it may be unknowable to us if the perpetrator owns a firearm. There is no clarity on how the policy will be enforced. If and when firearms are involved, if they have an HQL, they may be able to obtain another one. Peace order status should be listed as disqualifying respondents from eligibility from purchasing a firearm. Peace, unlike protective orders, can be obtained only in district court during business hours. My alleged stalker resumed their behavior at night. I was unable to get notice about their release from incarceration. Protective orders are available 24 hours a day, 7 days a week from district, circuit, and other locations, and court appearances can be virtual. This is left unresolved. Thank you for the opportunity to provide testimony on SB 743. I hope you consider this.
Good afternoon, Mr. Chair, Mr. Vice Chair, members of the committee. Here in support of Senate Bill 743 with amendments. I'd like to thank Senator Waldstreicher for bringing this bill and for working with us so closely on the amendments. We agree that stalking, stranger stalking, intimate partner stalking, and stalking by people who you don't even know is an incredibly serious issue. However, this bill as drafted has the protections in the protective order statute, and we believe that it belongs in the peace order statute, and that is what the amendments would do. It would also do a few other things. It would extend the length of the peace order, and it would provide a path to permanent peace orders, as well as include discretionary removal of firearms upon certain factors being proven. In addition, it would improve the path to a permanent protective order for those that are eligible for a protective order. When I saw this bill, took the time to look at every other state to see how they handled it for stalking. I looked at 37 states that have specific civil orders directly related to stalking. Maryland is incredibly out of line in terms of its duration, in terms of its protections, and the discretionary removal of firearms. So the 6 months, there was only one other state, and it was a combined order, and it involved child custody. So it was totally incomparable to what we have here. So we believe that the protections that the amendment would offer would benefit both victims of stranger stalking as well as those of intimate partner violence, and we urge a favorable report with those amendments.
Good afternoon, Mr. Chair, Mr. Vice Chair, members of the committee. I'm Lisa Jordan with the Maryland Coalition Against Sexual Assault. We're also here in support of the Senate Bill 743 with amendments. You know, protective orders, as you've heard, really are the first line of defense for intimate partner violence. But I do want to point out that it's not just for intimate partner violence. It's also for sexual assault cases. Non-intimate partner sexual violence cases moved from the peace order to the protective order several years ago because of some of the things you've already heard about. They're longer, they're generally viewed as more serious. There are other forms of relief that flow from the protective order statute itself. As you've already heard, Senate Bill 743 does two things. It moves stalking similar to how non-intimate partner sexual assault was moved. And MCASA honestly views this as perfectly reasonable. It is a reasonable option. The U.S. Department of Justice, Office of Violence Against Women generally has jurisdiction over domestic violence, sexual assault, stalking, and of those 60% of non-intimate partner stalking cases, a lot of them want to be intimate with the victim. So it kind of fits, but it also fits in the peace order statute. So if the committee desires to put it there, that is also a perfectly reasonable option. The second thing, though, I really do want to highlight, and that is that it would expand the availability of permanent protective orders. This is really sorely needed. It's an important change in our statute to be able to have ongoing protection. There is a kind of a drafting error in the bill. It refers to crimes of violence in the criminal law article that would inadvertently take out assault 2, which is really important, right? That's lots of the intimate partner violence cases. So we ask either that you switch to public safety or that you specifically include assault 2 to permanent protective orders. For those reasons, we ask for a favorable report of Senate Bill 743 with amendments.
Questions from the committee? All right, with that, thank you all very much. We'll be in touch to work some of this out.
Mr. Chair, if I'm not out of line, I believe Ms. Feinstein is desperately waiting in the waiting room.
Yes, and yes, and Ms. Cross. So Ms. Feinstein, we'll go with you first, and then we'll go with Ms. Cross next.
Thank you so much. My name is Debbie Feinstein. I'm Chief of the Special Victims Division for the Montgomery County State's Attorney's Office. Good afternoon to Chair Smith, to sponsor Vice Chair Waldstreicher. The issuance of a protective or a peace order is not directly in the lane of the State's Attorney's Office. However, as I testified on other bills, the incidence of stalking and the nexus to other types of crimes, particularly homicides, is of great concern to the state. Anecdotally, we've handled a lot of stalking cases, both intimate partner and non-intimate partner. And in some of the non-intimate partner cases, the stalking, as we just heard described by Ms. Williams, can go on for years and years and years. And the recourse that's being suggested now, either putting this non-intimate partner stalking into the protective order bill, or protective order statute, or the peace order statute, makes a lot of sense, because the duration of 6 months that's available under the current peace order scheme is simply not enough time and not enough protection for these serious cases of non-intimate partner stalking. And so we would advocate for either option, putting it in the protective order or putting it in the peace order statute. Certainly hearing what my colleagues and advocates have to say with respect to the proper placement of this. I would also concur with what was just said by Ms. Jordan regarding the need to update and change the protective order, the permanent element of the protective order, and broadening it to include crimes of violence as defined under the public safety article, which would include assault in the second degree. For all those reasons, we would urge support. Thank you for your time.
All right, thank you very much. We're going to go on to Ms. Cross, then we'll take questions from the virtual panel. Ms. Cross, you're up.
Thank you so much. I do testify favorably in response to Senate Bill 743. This protective order is something that's necessary. Stalking is actually a debilitating action. When you are being stalked, and trust, many of us that have unfortunately been miscategorized as weak has had this opportunity to be stalked, and it's not fun. You cannot answer enough emails. You cannot put enough into the trash box. Those things are very debilitating, not only to your work life, receiving nude pictures at work, receiving things that could get you fired from your job. I adamantly request that you push a favorable on this. I have worked with Patricia Watts and Connect to Protect and We Model USA, where they bring fashion to the world of protection of not just women, but men and children as well. They're bringing the mission and the vision of highlighting that it's not just a victimless crime anymore. When you are socially and with social media and all of the media aspects of our lives, from paying bills, all these threats are criminal. When you look at Cyber Command addressing criminal issues on the network, you get a Trojan, it tears your entire system up. You get a virus, it tears your entire paying bills system up, which can throw everything in your life into a vicious cycle. I urge you to favorably agree to make Senate Bill 743 law. Thank you.
Questions from the committee? All right, seeing none, that'll end the hearing for Senate Bill 743. I think you're very much. All right, we're now going to Senate Bill 773. Senator Waldstreicher.
Thank you, Mr. Chairman. If I could bring my panel up. for this bill. I was shocked that this wasn't already law. And you may be shocked as well. Under current law, a homeowners association or a covenant can ban people from renting houses. I didn't know that. Not just like short-term rentals like Airbnb, which makes sense. Airbnbs can be disruptive to communities, but they can ban any rentals. Every house has to be owner occupied. And not just a covenant that comes with a deed, the homeowners association can just decide this for the entire community. We know that renters are disproportionately lower income, disproportionately African-American, disproportionately people of color. That means a homeowners association that bans long-term rentals are impacting our most vulnerable communities, especially. Again, I didn't realize that anyone in the state could do it. It's against public policy, and we should have banned this a long time ago. You're going to hear from someone whose community decided to do this, and he went up against his community association in an attempt to change this to allow long-term rentals in his own community. Just to be clear, this does not apply to Airbnb, Verbos, any type of short-term rentals, vacation homes. This only applies to long-term rentals. With that, Mr. Chairman and members of the committee, I'll ask for a favorable report on Senate Bill 773.
Good afternoon, Mr. Chairman, members of the committee. My name is Sushant Sid of Capital Strategies here on behalf of Potomac Development. Just to reiterate what Senator Waldstreicher said, this is a very straightforward bill. It limits the ability of HOAs to restrict long-term rentals, which is defined in the bill as 6 months or longer. Again, it does not at all impede HOAs from restricting short-term rentals such as Airbnbs, VRBOs, which we do understand can cause somewhat of a nuisance in communities. Just a couple of facts on the Maryland housing market, actually public perception. So in the 2024 Maryland State of Housing survey that was conducted by the Maryland realtors, said that 82% of Marylanders believe that the cost of homeownership is too high. 81% believe that the cost of renting a house is too high, and 65% believe that there is inadequate housing stock for moderate families. And just to give you a snapshot of the rental community in the state, 32% of all households in the state are renters. 27% of renters, or 207,000 individuals, are considered extremely low income. And according to the National Low Income Housing Coalition, Maryland has a deficit of 146,000 affordable rental properties. This bill serves to provide homeowners improving neighborhoods through rental projects, stability in the marketplace. The state, given the data, the state should be serving to encourage renters in the marketplace, not allowing third parties to diminish housing stock. To be blunt, HOAs prohibiting rentals is discrimination, pure and simple, based on economics and income. It undermines programs at the federal level, like the HUD Housing Choice Voucher Program as well. We're creating programs, we're not actually letting them follow through. In addition to discrimination, there's the issue of property rights. Property owners should be able to rent to whomever they like, and restrictions should not be based on income. So long as a tenant is in compliance with cosmetic and behavioral standards, they should be allowed to rent. We have written testimony from several folks, Baltimore Regional Housing Partnership, Disability Rights Maryland, Site Insight, and the Public Justice Center. Thank you.
Good afternoon. My name is Gregory Portnoy. I'm a landlord of one of those houses that were affected by HOA restrictions. I'm a naturalized citizen. I came to this country with 2 bags and $30 in my pocket. So I do understand how important is rental for people with low income. And when I bought this house in 1913, I decided that renovated it and start renting to low income people. In 2018, our HOA modified the rules, restricting, basically, ability to rent the houses. In April of last year, I was notified that unless I get rid of my renter, I will be, they will sue me. The HOA will sue me for damages, and I will pay all their legal bills. From April to October, I'm forced to engage a legal firm in order to give my tenant ability to find some new housing. The new housing was especially hard for her to find because she had a kid with that need help. So I think it's important for us to restore the ability to rent the houses for people with low income. Thank you.
Good afternoon, Chairman Smith, Vice Chairman Waldstreicher. My name is Tim Weens. I'm the Executive Director of Maryland Inclusive Housing. We have submitted written testimony, but I'll have a few comments. We were started 4 years ago as the state of Maryland, the Maryland Developmental Disabilities Administration wanted to begin moving residential services from a group home model to a supported living model where people lived in their own apartments or homes. And so not to close group homes, but to create more options. And so we have done that by creating housing committees around the state that work with developers, with housing commissions on creating more affordable housing. We have an information clearinghouse on our website. And we provide what's called housing support services, which is kind of housing case management. So we work with individuals with developmental disabilities and their families to find housing that's affordable and accessible. And so a lot of what we're doing is overcoming barriers to that, many of which are affordability. Very few of the people that we serve are going to ever be able to buy a house. And so restrictions for homeowners associations that don't allow for rentals mean that people with developmental disabilities, unless they're living with their families, wouldn't be able to live there. Many of the people afford housing through various kinds of housing vouchers. Again, they would not be able to use those vouchers in this kind of arrangement. Just as I think the state of Maryland is working toward creating more affordability for everybody in terms of housing, this bill, I think, would help people with disabilities. So we're in favor of this bill. Thank you for your testimony.
Thank you very much. Senator Charles, and then Senator West and Senator James.
Thank you, Mr. Chair. Mr. Vice Chair, I think this is a great bill. Like you, I did not realize that this was I thought it was just it could happen. My neighborhood, my community is considered a condo community, townhomes, but we also have a lot of condos, but because they share water. And one of the things I always thought was unfair about it was they did it based off of percentages. They say, you know, at least 60% of the homes have to be owner occupied. So what happens when everybody beats you to the punch and now you're stuck with being the home that you can't rent your house out, but everybody else can rent theirs? Does this have an impact on communities like mine as well, where it will get rid of that their ability to put in provisions to say only 60% can be, or 40% can be rented out, so it's not a majority renter occupied community?
That's right. Yeah, this bill would get rid of that regulation established by the homeowners association. And just to be clear, it doesn't go to the next level. In other words, lots of communities and most leases have a restriction on subletting, because then you're kind of distant from the original person and the original owner doesn't know who's in the unit because the renter is subletting to an additional renter. This doesn't disallow that. This just makes clear that anyone can rent their property.
Yeah, I think this is a fair bill.
Yep.
Thank you, sir.
So this, thank you, Mr. Chair. This is questions for the sponsor of the bill. At first blush, this sounded great. I think it still sounds good, but I'm thinking about situations in which people who control a property are concerned about disruptive people moving into the property. For example, in an apartment house, it typically it's typical for the landlord to be careful about who the landlord rents to, lest the landlord rent to a disruptive tenant who will cause other tenants to leave at the end of their leases. So in a cooperative, once again, it's not at all unusual for there to be an interview between the existing owners of the cooperative and someone who proposes to buy into the cooperative, because they don't want a disruptive member who's going to create havoc in the relatively small group of people that collectively own the cooperative. So homeowners associations, I guess, are a little different because everybody owns their own home. And typically, I guess, they're either townhouses or they're separate. But there may still be situations in which you're concerned. For example, if you got townhouses, you worry about someone, for example, smoking marijuana in one townhouse and the odor seeping through the walls into the adjoining townhouses. You wouldn't want that. So I guess the way around this, it would be not to prohibit the long-term rentals, but still to allow the management of the homeowners association to condition living in one of the homes in that association to meeting certain benchmarks. For example, if you have an elderly area, you wouldn't want a family with small children to be moving into one of the townhouses and with the kids running around and yelling and screaming and perhaps bothering the people in the adjoining townhouses if it was set up to be an elderly community. So do you think that that this bill would have any impact on homeowners associations imposing those sorts of restrictions? Not a long-term rental restriction, but other restrictions which would keep undesirable people out.
So let me take that in order.
Sure.
So first of all, this doesn't apply to cooperatives.
Right.
So Maryland, we don't have a lot of cooperatives relative to other states, but to the extent that we do, it does not apply to cooperatives. It only applies to homeowners associations.
And it wouldn't apply to apartments.
That's right. Number two, age-restricted housing. Age-restricted housing is restricted by law, and that is allowed in another section of the code. So this would not disallow age-restricted housing. So I couldn't buy into a 55 plus housing unit if I'm over 55 and then use that 55 plus unit to rent to someone under 55. So this doesn't abandon that scheme. And then the last thing, the core of your question is, yes, of course, homeowners associations, as Mr. Sid indicated, are completely allowed to maintain rules of social norms, behavior, expectations, and to be honest, to go beyond that, right, into places I think some of us have concerns, but nonetheless are completely legal. Paint color, what you can and cannot have in your front yard, the decking material that you're allowed to have, none of this touches that, both on the real serious stuff and on the optic stuff.
Great, thank you so much.
Initially, my response was somewhat like Senator Charles, but then as my mind starts going, and I was thinking about a story that I saw on 60 Minutes when it was talking about how Wall Street was going into these communities and purchasing homes and then renting and essentially changing the character of the communities, and how some HOAs, they were battling Wall Street by putting in these kinds of restrictions about who could purchase and then rent homes. And it seems this legislation would prohibit that type of activity when you're trying to essentially build a neighborhood in a community, but you aren't able to do so like you like because of corporations purchasing up your community. Would you mind speaking to that?
So yes, Senator, I do. I'm sorry. I have heard of these situations where you get corporate housing interests that buy up neighborhoods. I think with respect to this bill, I think we have a larger issue in the state of Maryland in that we don't have enough properties available for rent, right? So we have a good citizen that's trying to improve a neighborhood by fixing up a house and offering it for rent through the 8A program. And then you have the homeowners association for, I don't think, any reason whatsoever. So I mean, to Senator West's question, I mean.
But wouldn't that person have known when they purchased the property that the HOA had already had those restrictions in place?
Well, I think the question, well, actually, no, this happened after the fact. He had bought the property, rehabbed it. The homeowners association then passed the bylaw. After the fact, he was renting to someone that was on the voucher program.
So to the point about the corporate takeovers of communities.
So, yep, I think that's important. Let me just say it a little more explicitly than perhaps Mr. Sid wanted to say it. They changed the rules because he rented to an 8A, a Section 8 tenant. I mean, that's what's happening here is not subtle. And so I think you have to weigh that issue against the more theoretical risk that you're indicating. Now, I saw this piece that you're talking about, and there is this trend. I think that you see that trend reversing because lots of large hedge funds lost money on that. But I think if you're looking at the problem is much larger among communities that are seeking to use stereotypes to control who does and does not live in their community, as opposed to addressing issues related to hedge fund ownership of homes. And just to finish, I'm sorry, I apologize for interrupting. A lot of the issues that came up with corporate ownership of individual houses was in not just the costs of that they're driving up, but about the upkeep of the property. And just like with Senator West's question, the upkeep regulations are completely allowable under this bill. So if somehow a house gets owned by some hedge fund from New York City and they're looking to squeeze every penny out of it and they don't keep up the painting of the exterior, the HOA can fine the company and say, you got to paint the exterior, you got to keep up the house.
Why wouldn't the laws that we currently have in place with regards to discrimination and housing, why would an act or an action not be able to take place under the current law?
Because the HOA lawyers knew that this wasn't the law, because they're smarter than they could listen. I just want to be clear.
You said it's essentially a Section 8. It's a source of income thing. I mean, if it's that clear.
Because they can say pretextually, oh, it's not source of income. It's not the color of the skin. It's not the child's disability. It's because we just made a rule that said you can't rent out your house. And that rule is pretextually race neutral, disability neutral, source of income neutral. And I mean, they made the rule because of the individual tenant. It's not like this was going with the deed, like you said, where it was existed before the renovation and the rental happened. They made this rule for this particular tenant.
Thank you.
Thank you.
I thought you were going to make a play for your bill and say it would be helpful if they recorded it, Senator James.
Thank you, Mr. Chairman. In a way, this situation reminds me of bad cases. Hard cases make bad law. And I'm very sympathetic to the particular circumstances that brought this about. But in my county, for example, we have the exact opposite problem, which is that we have lots and lots of concentrated rental properties, and those that live there year round are frustrated as all get out with the rental and the absentee landlord situation, right? And I've worked in the HOA world for a long time, and I'm surprised you're surprised that this is the way it works generally, because the whole point of it was not to discriminate based on the protected classes, but to protect property values, right? To make sure that the tenants that are coming, or the prospective owners, and they want owners because they believe that's a stronger investment in the property. So I give that and would tell you that I would seek to have Harbor County taken out of this until I could, get back to my own community and see how they would feel, since this is a very problem they're having. But I also wanted to just ask a few questions about how it was drafted. I never thought of a 6-month lease as being long-term. And I thought initially when I just saw the title of the bill, I said, oh, Yeah, maybe if you're renting to somebody and they're making a long-term commitment that's very almost in parity with people that can't quite afford to buy a place, but really want to live there a long time. And then maybe we could even graduate to, you know, the rent starts going toward the purchase. But 6 months, I don't know where you got that, but in generally speaking, my experience has been that is not a long-term lease, for one thing. I agree with Senator Senior. The other problem is obviously a lot of very smart business people come in and buy up properties and do exactly what he's worried about, which is part of our problem in Harford County. Then I would just ask for some data. I totally get this low income housing stock problem, but I'm not clear that homeowners association housing fits into that. I don't know. I'm just asking. I don't know if there are a lot of low income homeowners associations where these are very, very inexpensive properties. That could be true, and it might be true in your area. So I'd like a little more about that. And then other states that have obliterated this general authority of homeowners associations. And I'll give you some other examples. Ocean City, this is a very important at a tourist location, right? New York City, very important in that urban setting. So those are sort of the questions. You can get back to me on all of it after the hearing, but that's some information I'd like to have regarding the bill.
Can I just address the first one real quick?
Which one?
The
Oh,
issue
sure.
of long-term, short-term.
Yeah.
If you were supportive of the bill at 1 year and not 6 months, we could go up to 1 year. In Montgomery County, where three of us are, Delegate Senator Kelly and I border the National Institute of Health. So we have a lot of doctors who are coming into town and doing a rotation at NIH, and they rent for about 6 months. So these are not people who rent Airbnbs, but they're not doing a 1 year stint because of the way NIH works. Occasionally you have professors coming in to teach for a semester. They'll often rent in Bethesda or Silver Spring or in Prince George's County to go to the University of Maryland. And so it was that community that we were thinking of when 6 months came up, because oftentimes they're shorter than 1 year.
Are they having problems themselves? Because I thought this was all about low income and affordable housing.
I think there are some communities in Montgomery County where this is a problem. I think you're exactly right that this is mostly affecting low income people because it's used as a pretext to keep low income people out. But I do think at the higher, doctors, people coming in for specialized medical rotations, it is impacting them as well. But again, I think we can go up to 1 year if that satisfies your concerns.
Well, I would also say that I get that this is a problem in Montgomery County. I'm not aware of it. I'm aware that we have a housing problem, low income, affordable, entry level, get that problem. Not aware that this would be solved with this bill in my county. So I'm pretty sure nobody communicated with the people in my county. So that's why I'm raising these concerns. Very different circumstances. Thank you.
All right, thank you very much. Seeing no further questions, thank you all. I have not seen him. Is Matt Hill here? All right, we have Mr. Ratnow joining us virtually.
Yeah.
Welcome. All right, thank you very much. Seeing no further questions, thank you all. All right, Mr. Ratnow, if you could close down your browser or mute it, just so we get the feedback. Good to see you. Welcome.
Hello, I'm
virtually.
Hello, thank you all for taking the time to listen to my testimony. I'm an affordable housing developer, owner, and operator. Thank you. And I own. Sorry, I may.
Close down your browser or mute it.
Yes, sorry. There, is that better?
That's better. Yes, we can hear you. We've reset your time, so go ahead.
Thank you very much. My name is Jeff Ratnow. I'm an affordable housing developer, and I develop scattered site housing. I own some rentals in homeowner association communities, and I did actually check the homeowners association bylaws to make sure that I could have rentals. But I also did not know that the homeowners associations could change the rules on us after you purchase your home. So I am in favor of this bill. The units I own and operate are well managed, are heavily regulated. I get inspected every year. I have to comply with HUD. And I would actually counter argue to add to my testimony based on some of the things I've heard so far. I take better care of my rentals than I do of my own home down in South Baltimore because, you know, of all the regulations and oversight, and you have to. When you're a homeowner, you don't have to. So I think that is a little bit of a misnomer that homeowners are automatically better neighbors, better folks that take care of their homes, especially since we're highly regulated. The other point in my written testimony, I also wanted to make, I do horizontal ground up development for folks as well, and all new developments, especially to national homeowners, they are automatically going to have HOAs to own and manage the public spaces, whether it's roads, stormwater management, forest conservation, recreational areas. So unless this is prohibited, every single new housing development in Maryland from here on out that's not in Baltimore City in existing non-HOA blocks will have the right to block rental housing. And it could be pretty devastating for those who don't have the bank loans to purchase their own homes. Thank you for your time.
Thank you for your testimony. Any questions for this witness? Senator James, did you have a question? Oh, okay. Your light was up from last. It was earlier, but I think it was from last time. I apologize. All right. All right, seeing no questions, that concludes the hearing for this bill. And there are no opponents for that bill. So that concludes the hearing for 773. Thank you to the witnesses. We'll now go to Senator Kelly and Senate Bill 759.
Thank you so much, Mr. Vice Chair, for hearing 759, Senate Bill 759. This is my no good deed goes unpunished piece of legislation. We're going to take a little stretch here. We're in the final stretch. I know we have Senator Charles Day coming up. 5 of his bills are coming up. And then at the end of our hearing agenda is the chair's really important kinship care bill. That's a departmental bill that I really love. So we got to start paying attention here. This is going to be a bit of a bill hearing because I have 8 proponents signed up and there are 9 opponents signed up. So I'm apologizing to the committee in advance, and I'm going to give you a little bit of backstory about why it's important we have this discussion. Normally, I don't like to take up that much of the committee's time. So I want you all to be aware why this is such an important important use of our time to consider this issue. So Senate Bill 759 deals specifically with petitions for guardianship from healthcare settings. It would require a court to rule on petitions to appoint a guardian of the person to make decisions related to the discharge from a hospital or potentially a healthcare setting within 10 days. And the second thing it does is it allows hearings to appoint a guardian of the person to be held virtually. So that's what the bill does. The backstory to this is a conversation that has been going on at least since 2011 in the state of Maryland. If you know me, and I know Senator West and Senator Charles worked with me on HGO, you will know that, I am here to be a champion for the vulnerable, and particularly people with disabilities and the elderly have a tremendously soft spot in my heart, and I only want to do work that protects them. So please keep that in mind as we have this conversation, because it's a difficult one. There was back in 2011 legislation similar to this that was introduced. It resulted in a work group, which resulted in some recommendations, which resulted in a judicial ruling, which resulted in a federal grant being received to look at this issue. This has been a conversation that's been going on forever. Most recently, there was a hospital throughput work group that was assembled Chair Beidle of the Finance Committee, which deals with healthcare, is on that work group. Vice Chair Bartlett, who is the cross-file of this bill, along with Chair Pena Melnick over in the House side, as well as Chair Beidle, have put this bill in with me because we do think it is an important conversation that we have and pay attention to. And it's not an easy one. I'll say that over and over again because you're about to hear strong arguments on both sides of this case. The goal, though, with this legislation is to acknowledge that there's a real problem, particularly with Maryland's emergency room wait times, which are, of course, the longest in the nation. We've all seen the headlines, and we need some meaningful solutions. I want to really acknowledge, because as you go through and hear the opposition, that guardianship needs to be a last resort. I wholly agree with that in all of the testimony that you'll be hearing raising that issue. And I think that everyone understands that. And I also want to acknowledge that sometimes guardianship is necessary and we need a process that's going to work for the people of Maryland. You're going to hear testimony that there are patients who are not in need of hospital care who are lingering for up to 4 months in hospitals awaiting guardianship decisions, which is not good for us. It's not good for the patients, and it is not good for the general public that needs access to the emergency rooms. Again, I'm going to be fully honest with you. The opposition panel includes pretty much every friend I've ever made during my 14 years in Annapolis on this bill. And so that's really hard for me. You will hear them raise concerns about the potential for the overuse of the guardianship process and concerns about human rights being infringed upon. That is absolutely not the goal of this bill. And those concerns, I recognize the severity of those concerns. You'll also hear really absolutely accurate concerns raised about the fact that we're not investing appropriately in services and supports for vulnerable adults, and that our social services staff are overworked and underfunded. And if I could put in a bill to increase by tenfold the budgets for the area agencies on aging, I would do that. I guess I could do that. They haven't asked me to, but I recognize that we under-resource these folks. The caseworker load is way too high, for example. You're also going to see and hear, I believe, in person opposition from the judiciary who vehemently oppose this. In addition to their concerns that there's a healthcare to guardianship pipeline you'll hear discussed. There is a grant that they have been working on to address that issue. You're also going to hear suggested that we should just work a little bit harder with the 2022 bill that the vice chair passed dealing with supported decision making. So the proponents of the bill will address why that alone is not enough. I could talk about this issue for a long time. It's really complicated, but I think the committee will be better served hearing directly from both the proponents, and I think we have 8 people here to testify, and the opponents. I will tell you where we are right now with this bill. Vice Chair Bartlett has been holding stakeholder groups conversations to see if we can get to a place where the stakeholders are a little bit closer together. If there's any language in this bill where we can come to agreement on, if there's any progress we can make this year. So those conversations are taking place, and I will keep the committee updated as they proceed. But what you will hear today is, I think there's still a lot of space between the two sides of this very, very critical conversation. And with that, I would love to call the panel of proponents up.
Absolutely. I can tell you who I have here, and Ms. Helen Hash, Mr. Peter Tallarico, Ms. Sigrid Haynes, Ms. Allison Taylor.
On behalf of me. Okay. Thank you, Mr. Vice Chairman and members of the committee. Peggy Townsend on behalf of the Maryland Hospital Association in support of this bill. And I really want to thank the sponsor because I do know she has a lot of friends, and I don't want to get between her and her friends, but this has been a very, very long-standing issue for hospitals. The situation occurs when there's an individual who is incapacitated and needs a guardian appointed to make a decision to allow them to be discharged to where they need to go next, rehab or nursing home. And they languish in hospitals 2, 4, 6, 8, 12 months waiting for a guardian to be appointed. It is not unusual. It takes a very long time. You will hear from these panelists that they do make extraordinary efforts to try to find surrogate decision makers it's in the hospital's best interest to try to find a surrogate decision maker. We don't want to have somebody in our hospital that doesn't need to be there. But what has come about in the last 12 or 15 months is the problem hospitals are experiencing with the emergency department wait times. I'm sure you've heard about this issue. We have some of the worst in the country. Well, and there's a lot of factors for this, and this bill would help us in a couple ways. It's not the silver bullet to figure out ED wait times. There's a lot of things that need to happen. But what this bill does is when somebody's upstairs in a bed that they don't need, the people in the emergency department that are that need to be admitted are then boarded in the emergency department. So it really backs up things. And if the patient's there for 4, 6, 8 months, that's a number of community individuals that can't have access to that bed. So it's a multiplier effect, if you will. We do think, we're very clear, we think guardianship of the person is a final last resort, but we think the process could be quicker to help us appropriately care for these individuals. Thank you, Mr. Chairman.
Thank you. Whoever would like to go next.
Good afternoon. My name is Helen Hash. I am the Director for Care Management at University of Maryland Medical Center, and I'm speaking on behalf of our 13 hospital system at University of Maryland Medical System. I'll start with some numbers. In calendar year 2022 and 2023 combined together, we had 69 patients spend 4,384 days in the hospital that they did not need to be in the hospital awaiting guardianship. The average length of stay was 64 days. More than 1/3 of those days were accumulated and incurred at University of Maryland's flagship hospital in Baltimore City, our only tertiary and quaternary care hospital, where patients across this region are waiting to be transferred for life-saving treatment. Please know, though, that this testimony is not about numbers. It's about people, the people inside of the hospital waiting. One patient waited 80 of their 101-day hospital stay for guardianship. And that was from the point in time when the guardianship paperwork was filed until the guardian was appointed, and additional work was with the guardian to find suitable next phase of care. The people outside of the hospital are also part of this discussion. Those waiting in the emergency departments and across the region, including surrounding states, experiencing very long wait times to get the care that they need, waiting to be admitted to inpatient beds for life-sustaining treatment for cancer, heart surgery, trauma care, other medical surgical procedures, and physical rehabilitation. This testimony is not intended to strip patients of their rights. In fact, we had one patient who was appointed a guardian, received her care, and as a result of her care, regained her faculties and had the guardian removed afterwards and was discharged home on her own accord. Thank you for allowing me to testify.
Hello, members of the committee. Thank you for addressing this important issue. My name is Peter Tellerico. I'm the Director of Risk Management and Patient Safety for Holy Cross Health. I am a registered nurse, but have spent over 20 years in risk management dealing with guardianships. Guardianships are the least efficient way to assist a patient to an appropriate living or care setting after hospitalization. Hospitals do everything possible to avoid them. Starting at admission, patients with family or friends are advised to prepare for what patients might need after they leave the hospital. Sadly, many of the patients requiring guardianships have limited community and family support. For some, simply identifying who they are can be a challenge. Of necessity, care providers have become adept at searching for personal information. All leads are followed. Checking cell phones for emergency contacts, searching healthcare records, including CRISP, Health Information Exchange, are now routine activities for healthcare workers. Sometimes the police are called to fingerprint a comatose patient just to establish their identity. In other cases, a private investigator has been employed to pursue leads and has even been sent door to door seeking contacts. Homeless shelters, local embassies have been queried. Many international phone calls have been placed seeking anyone who can speak for a patient. It is only when all of these options are exhausted, and this can take weeks, that guardianships are pursued. A 2-week hospitalization can easily extend to 2 months or longer. The guardianship process provides the patient with a court-appointed attorney and guarantees a hearing in front of an impartial judge. These actions provide options for patients who otherwise would not have access to them. The patient would simply languish in the hospital room with no advocate. Making hospital-initiated guardianships a priority for the courts would help some of the most vulnerable patients secure a more therapeutic environment and would help to alleviate the backlog of patients in Maryland's emergency rooms. Thank you.
My name is Sigrid Haynes. I'm an attorney in private practice, a partner at Whiteford Taylor. I've been practicing guardianships, filing guardianships, and serving as a guardian for almost 40 years of my career. One of the problems that we have with hospitals, as you heard, is that we simply often don't know who these patients are, or they don't have any community support. I am aware of a number of situations in my professional practice where we simply have patients who don't have any community support. It was great that last year the Maryland passed the assisted living concept, or I'm sorry, the assisted decision-making concept. And that was helpful for patients who have someone who's able to assist them with making decisions. Many of these patients do not. Further, it does not help when you have a situation, as almost all of our patients do, where they have financial issues that need to be addressed. The first thing that people lose is their financial capacity. There are adequate medical studies on this. Financial issues are more abstract. People know whether or not they want to have surgery, but they don't know where they bank or whether they filed their taxes. Or if they do, the banks won't cooperate with somebody who walks in and says, I'd like to have the financial records of so-and-so who I'm helping. For obvious reasons, the banks are very reluctant to help in that situation. A power of attorney requires that the patient be sufficiently competent in order to grant one, and that there be somebody willing to serve. And that is not often the case. So we often end up filing guardianships, and these patients are sitting in the hospital, and it's not an abstract concept. It could happen to anyone in this room who doesn't have a family member willing or able to step up, or there's a family fight as to who is the correct decision maker. So it's important that we get these cases heard through the courts. And right now it's taking 3 months, 4 months, 6 months for us to get a guardian appointed in these cases. So we do think it's important to have these cases heard more quickly than they often currently are being heard. Thank you.
Good afternoon. My name is Allison Taylor. I'm here on behalf of Kaiser Permanente today. As many of you may know, Kaiser is an insurance company offering coverage for about 500,000 Marylanders and offers care through a network of physicians that are exclusively available to Kaiser members. And Kaiser has dedicated space in hospital where their physicians see members, and the issues that the hospitals have raised also affect Kaiser and Kaiser members. So we're happy to work with stakeholders and appreciate the opportunity. Thanks.
Thank you all for your testimony here today. Let's pause there and see if there are any questions for the sponsor or this panel. All right. Senator James.
I would hope that you all have had an opportunity to read the Maryland Judiciary's opposition to this. I imagine you're rather familiar with it, though, since the issue's been around since 2011.
Yes.
So, it's clearly a thorny issue.
It is.
And also not a new issue.
No.
Right. And I've done guardianships before. So I think what they're trying to say, I don't want to put words in their mouth, is that in a way, which is what government does, we all do it. We take a sledgehammer to kill a gnat. And I'm not saying this is insignificant, but I am saying that we're turning the whole process on its head, because guardianship is an extremely important, complex process. And it does, I hate to use Britney Spears because that's not a great example, but she really brought home to young people just how restrictive, onerous, intrusive this is. So if that's what it is for a young woman, imagine what it is for an older person or somebody who is suffering under some cognitive disability, maybe brought about by their recent healthcare problem. So I would just suggest to you all that they say this, and I think this is what we want to get at. How can we help facilitate the consent for placement? Maybe not retrofitting it into this onerous, rightfully deliberate process of guardianship. And not right now, I guess, because I'll listen to the opponents and maybe they'll have some ideas, but I feel like there's got to be a better process than what's in this bill. I also will just say to you that I'm talked to some of the opponents who I've known for decades and really respect, and on 10 days is a virtually impossible time frame. So even if we were to come up with something, it probably could not be in that kind of lightning speed process.
Of course.
Okay.
And
anything you want to
Well,
say,
well-
Peggy, I'm always happy to hear what your thoughts are.
we were so tired of just hearing no. And you're not doing a good enough job. It's, no,
Right.
no. So that's what really brought us here to sort of start the conversation, because 10, 13, 15 years we've been dealing with this, and we're getting really frustrated.
And honestly, we are an aging population.
It's gonna get
The
worse.
good news is we're gonna live longer. We're all gonna hopefully live longer. And so just by virtue of, the way the bell curve is, we'll have some people living longer who also have outlived or do not have close relation. So we ought to come up with a holistic, systematic process. Probably might not be the full-blown guardianship process, but something that both meets your needs, but then also respects the dignity and individuality of everybody.
I would just say, we tried to make this bill very narrow just for discharge.
Right.
As a way to narrow it. We understand the concerns about guardianship.
Yeah. All right. Thank you.
Any other questions for our first panel or the sponsor, Senator West?
Thank you, Ms. Downson. That your last sentence triggered a question. So about discharge. So if there is someone who arrives in the hospital, you don't know who the person is, there's no identification, and you try to take care of them, and you've reached the point where you could discharge the person medically safely, what does the hospital do?
The patient sits in the bed.
Oh, so there can't be a discharge
No,
because the
except
patient.
they lack capacity to make a decision.
Okay.
So that's the situation we're trying to fix.
Okay, thanks.
Great. Seeing no questions for this panel, we'll move on to the next panel. I have Hannah Kozacek. Hannah, you're signed up twice, which is okay. Jake Whitaker, and I think that's it.
Good afternoon. Thank you, Mr. Chair and the committee for this time. My name is Hannah Kozacek. I am a social worker of 20 years and the director of social work at Johns Hopkins Bayview Medical Center. As social workers, we are committed to finding least restrictive settings and treatments for our clients, and we are also tasked with ensuring vulnerable clients without decisional capacity have someone who can speak for them and represent their values and needs. While we do not wish to increase the volume of guardianships in our community, we seek expediency for those who absolutely need it in order to quickly get their day in court. I'll share a story about a patient who came to Bayview just this year. He was in his mid-60s and sustained a motor vehicle accident. He had little to no social support, and he had significant vascular dementia. Our team worked very closely with our legal department, outside counsel, and corporate security to try to locate relatives or potential surrogates. Leads for 8 different family members did not come to fruition. One son-in-law briefly agreed to act as surrogate and then rescinded. Our hospital petitioned for guardianship of person and property in order to provide him with a decision maker to speak on his behalf and help him access and apply for benefits. Following the hospitalization, this patient needed full-time care. He was able to access this care in the community at a highly skilled assisted living facility. A guardian of person was appointed, as well as property, allowing for someone to consent for plans and continue to manage his needs in the community. The challenge I want to highlight today, which has been shared, is that from the time of filing the petition, the hearing was held and court orders were received 47 days later. He did not need to be in the hospital for any medical reasons during those 47 days. This meant time in one of the most restrictive environments, a hospital room, where there is limited socialization, limited specialty programming, such as programs for dementia or traumatic brain injury, and an increased risk of infection and delirium. For patients who do need a guardian in order to receive the care they need, we ask for expediency. Thank you.
Thank you. Is Mr. Whitaker also testifying? Okay. All right. Do we have questions for Ms. Kozachek? Mr. West, Senator West.
Thank you, Mr. Chair. So as I'm going through the testimony pro and con and familiarizing myself with the issues here, wouldn't it make sense to create some sort of a work group to try to work through the summer and get all the interested parties? Everybody on both sides are people of goodwill who I'm sure want the best outcomes for these unfortunate patients. And wouldn't it be possible to come up with maybe not a perfect solution? There probably is no perfect solution, but the best solution under the circumstances if we all work together.
I absolutely agree. I think the tension between the values that we all hold are similar. And as some have mentioned, I think there's opportunity to keep working and try to find something that could fit everyone's needs.
I'm thinking, increasingly we're trying to identify different levels of care. And it strikes me that maybe we need, in addition to hospitals, which have a high standard of care, high level of care, we need a lower level of care in institutions which would deal with these people. If we can't just discharge them onto the street and they still need care, but we don't need to do it at the hospital level. I'm not sure whether or not it means creating a whole new system of care in the state, halfway house kinds of things, but a work group could consider those ideas when trying to come up with an acceptable solution to this problem. That's my thought.
While I think there's definitely opportunity for more resources in general, one challenge is that hospitals must have a consenting decision maker. So even to go to another level of care, someone must agree to that decision, whether it is, as you say, the streets or a high quality full care program. And so I do think everyone gathering together with all the best intentions is the right step.
If people have creative thinking available to them, maybe we could devise a program which breaks some barriers that are in the current Maryland law, but which would sensitively deal with this issue. Thank you.
Senator Muse.
Thank you, and thank you for coming. And pardon my ignorance on this whole, this is something altogether different for me. The persons that was spoken of, that they were in the hospital for up to a year, is that because they have no family? Is that because they were homeless? I mean, how does one get into that situation? And I'm sorry.
There are a lot of reasons people are finding themselves sort of stuck in the hospital and unable to discharge. I think in this circumstance, the challenge.
Unable to discharge has nothing to do with their medical condition. These are people who could have been discharged a long time ago.
Right.
But for some reason, they end up, so the hospital actually becomes a homeless shelter almost, if for a segment. Is that correct?
Exactly. There are patients who are in hospital beds, in hospital buildings, who do not need to be there for any medical reason.
Gotcha.
Other than there is not someone to make a decision for them. And as you mentioned, they may not have any family. They may have outlived their family or be estranged from them. Sometimes there are family members and they decline because they're unable or unwilling for other circumstances.
And are there any legal concerns that a person would have in a family for becoming a guardian of someone? And this is probably apples and oranges, but something like, if I become a guardian of someone and they pass, am I responsible for their debt that they leave behind? Would that be? And so you're not responsible? No? So what would be so it's only because they just have no one? that right?
Right. And there are family members who share with us that it seems like too much of a burden in terms of time,
Financially,
maybe
yeah.
proximity. They might live across the country or across the world.
And I'm aware that I took care of my mom for I don't know, 15 years, and it was never below with all the hospital nurses and 24-hour nurses and all that stuff. I don't think I ever paid less than $60,000-$70,000 a year. So if that's a reason, I understand that. And there are no other options available for someone.
Right. Guardianship would only be pursued if there are no other options for a decision maker.
Okay, thank you. Thank you. Help me understand.
Thank you, Senator James.
Thank you, and I'm sorry. You said Senator West isn't here, taking a second bite at the apple, but had a chance to read this a little bit more. So just for people within earshot, I would like later on to get some data as to whether the hospital is admitting people that it probably should not have been admitted in the first place and then are stuck with this guardianship situation. That may not even be what's happening, but I'd like to know about it. And then I'm reading all about this grant to the Maryland Judiciary, who's coming out with a report in August of this year. So I'm a little perplexed as to why we did not wait to put a bill in next year. Are you working with the judiciary? Are you aware that the judiciary is working on solutions to sort of break this cycle of what's called, I don't know, hospital to guardianship pipeline? They've been working on a guidebook for healthcare organizations to give an overview of alternatives to guardianship. Are you all in the mix in this process, or at least, or if you're not, you're aware
We're
of it?
aware of it.
Okay, all right.
And it's not going exactly to the time issue. In several of our hospitals, I believe, were interviewed as part of the process. But I don't think it didn't sound like it was going to the time it takes to appoint a guardian.
Got it. And I guess what I would do is maybe ask the chairman or vice chairman if we could ask the judiciary to give us a little more information than just this shorter testimony and see what that status is and enlighten us a little bit. That I think would really help us work on this. Thank you very much.
I think we'll have some some opportunity on the opposition panel, but I would like to just, if I may take a little second answer at that as well, because I think Pagin was right. But it seems to me that the sort of one of the challenges in this conversation is that the goal of this bill is to address those folks who would be appropriate for guardianship and getting them placed in an appropriate place sooner. As opposed to the concerns that are raised, which is that this might potentially be a backdoor to increasing the number of people who are under guardianship inappropriately. And so that's where the conversation is. So so the goal, which you have correctly identified, is to just make sure that people aren't in the hospital when they don't need to be. That's not good for them. It's not good for the hospitals. It's not good for public health, but not to exploit the guardianship.
Very good. Thank you so much, Senator.
Great. Let's move to the opposition, please. Chief Judge Woodward, Sarah Walsh, Eloise Main, and Geddes.
Good afternoon. My name is Patrick Woodward, and I am a retired Chief Judge of the Appellate Court of Maryland. And for the past 10 years, I have served as the judiciary's multidisciplinary work group on guardianship issues. Guardianship is an important tool, but is intended as a last resort, as has been said. As former U.S. Representative Claude Pepper once explained, and I quote, "The typical person subject to guardianship has fewer rights than the typical convicted felon. They can no longer receive money or pay bills. They cannot marry or divorce. By appointing a guardian, the court entrusts to someone else the power to choose where they will live, what medical treatment they will get, and in rare cases, when they will die. It is, in one short sentence, the most punitive civil penalty that can be levied against an American citizen, with the exception, of course, of the death penalty," end quote. Maryland guardianship law is a model of due process. Alleged disabled persons are afforded rights similar to those afforded to criminal defendants, including a jury trial. This bill would undermine those rights and make it nearly impossible to defend against an unnecessary overly broad guardianship or to identify alternatives to guardianship. We understand that patients who remain in care beyond medical necessity stress an already overburdened healthcare system. Guardianship, however, is not a discharge plan. When it is used as one, the resulting guardianship is usually plenary and remains in place even if the person recovers. Stakeholders and others, including a work group convened by the General Assembly in 2011, have advised against the use of guardianship for discharge purposes. There are other options that the judiciary, through a 2021 federal grant, is actively working on this issue. For these reasons, I respectfully urge an unfavorable report. Thank you.
Good afternoon. My name is Sarah Walsh. I'm a civil magistrate for the Circuit Court for Baltimore City. I am responsible for overseeing the adult guardianship docket in my court. Baltimore City has the largest number of adult guardianships filings in the state. This is in part due to the number of hospitals in the city. We also receive the most requests for expedited hearings in connection with medical treatment. In fiscal year 23, a total of 199 expedited requests were filed across the state. 133 of those were filed in the city. Petitions for guardianship of person filed by hospitals almost always include a request for appointment of guardian of property, because most cases are not merely about consent to discharge or transfer. There is a financial piece. If the patient does not have capacity or a legal representative, a guardian of property may be needed. For guardianship of person, Maryland has a strong public guardianship system. There is no similar system for guardianship of property. Most of the cases involve low-income patients that require an application for medical assistance for discharge to a long-term care facility. Courts must turn to attorneys to serve as guardian of property when no one else is available. The attorneys serve on a low bono or pro bono basis. There is no source of funding to pay them, and attorneys are not lined up at the courthouse to provide this service. The reality is that if a guardian of property is needed until someone is willing to serve in that role, the patient remains in the hospital. And even if a guardian is appointed, the patient will not be discharged or transferred the same day. This financial piece is often the crux of the issue and is something the judiciary is actively working to address. The bill would set a 10 calendar day period wherein courts would need to hold hearings. This timeline would interfere with safeguards to prevent unnecessary or overly restrictive guardianships. There is no one size fits all here. Each patient is different, as are their needs, resources, and options. Finally, the bill sets a mandate for virtual hearings that is unworkable. Although virtual hearings are frequently utilized, we cannot ignore that internet access is a privilege. Not everyone has stable internet connection or devices that would allow for meaningful participation in these proceedings. For these reasons, I respectfully urge this committee to return an unfavorable report. Thank you.
Thank you.
Good afternoon. My name is Eloise Main. I am the Assistant Secretary for Grants Administration with the Maryland Department of Aging. As the State Unit on Aging, one of our central functions is to manage and distribute federal and state funds to Maryland's 19 area agencies on aging, who provide a variety of services, but most importantly, including court-appointed guardianship for persons aged 65 and older who have no other family member to serve as a suitable guardian where available. You have our testimony, but I'll focus on some key points. First and foremost, the bill will unacceptably compromise the rights of older people, not protect them, with an expedited process. An expedited guardianship process through the judicial system does not allow for consideration of the alleged incapacitated older person's autonomy and safety, or facilitate sufficient guardianship avoidance activities like identifying surrogate decision makers outside of government or utilizing the supported decision-making process. For our area agencies on aging, public guardianship increases the staff and caseloads in most counties where they are already stretched thin. And also, this bill will undoubtedly increase those cases. Attempting to approve our hospital system's emergency room wait time is an important goal, one that we all share. But getting there on the backs of the public guardianship system runs counter to our longevity readiness goals. Before we explore a drastic change on how public guardianship petition flows from hospitals, we should ask, what more can we do to avoid them? There's so much data collection, guardianship avoidance, and upstreaming work that could be done in partnerships and the Longevity Ready Maryland Initiative. We urge an unfavorable report for this bill. Thank you.
Good afternoon. I'm Ann Geddes. I'm with the Mental Health Association of Maryland. MHAMD is a nonprofit mental health education and advocacy organization. And I thank you for this opportunity to testify in opposition to Senate Bill 759. Older adults with serious mental illness would be disproportionately negatively impacted by Senate Bill 759. People with serious mental illness frequently have major medical conditions, which can lead to multiple hospitalizations. In addition, people with serious mental illness are less likely to have close friends or family members who could be identified to take care of the specific activities of daily living that the person may need help with upon discharge. In addition, when people with serious mental illness are placed into guardianship, they are more frequently placed into public guardianship, which is not ideal, especially when the public guardian is responsible for many people. We know that guardianship should be a last resort and avoided if at all possible. Other people have mentioned the many negatives, but Senate Bill 759 would result in more people ending up in guardianship. It is an easy but damaging solution. And I also just want to second the comment that the judiciary has received this $1.1 million grant and is working on initiatives to reduce the healthcare to guardianship pipeline. I encourage us to look at that first before we pass any bill like Senate Bill 759. Therefore, MHAND opposes Senate Bill 759 and urges an unfavorable report.
Thank you. Questions for this panel, Senator James?
First, probably a dumb question, although I've been told there's no such thing as a dumb question, but here goes. I'm reading in the bill, that the petition seeking appointment of a guardian is to obtain consent to discharge. So this is the dumb question. If everybody in the hospital and all the doctors and all the attending people say that the patient is ready to be discharged, is it true that you, as a patient, if I don't consent to it, I get to stay there? I mean, assuming I'm not disabled in my mind, but everyone else has agreed that I'm ready to go, but I don't. So that's just a real quick technical question. You're a panel. Somebody must know the answer to that. I have to consent to a discharge. Is that correct?
Yeah. Yes.
Oh, I did not know that. Okay, that's interesting.
You have to go someplace.
Yeah, I'm gonna leave. And I want to go home. So I have to agree. If I don't agree, I get to stay there until somebody kicks me out.
Yes.
Well, that might be a problem. Maybe that's a problem in the law, huh? And so then just to the judiciary, I know you are the third branch of government, totally respect it, but in a way, you've given us nothing, no hint of where you are and what might be some solutions other than being totally against this bill, which I am too, based on what I'm hearing so far. So I'm just hoping that you, if you don't want to do it on tape here, I'm hoping you'll share some of what is going on in writing to the committee so we may look at it.
We'll be happy to submit where the group, the judiciary, is on the federal grant, which they're actively working on at the present time. We are involving all of the stakeholders, including the Hospital Association. We're including those into the conversation. We're looking to try to find alternatives to the hospital to guardianship pipeline. One thing that has not been mentioned that the committee may want to know is that the judiciary has worked with the Hospital Association and with the other stakeholders to devise a new rule that went into effect in January of 2019, And that rule provided for a request for an expedited hearing for medical treatment. And as Magistrate Walsh indicated, there were some 1,800 guardianships that were filed in fiscal year 2023. 199, barely more than 10%, used this rule to get an expedited hearing. 133 of them in Baltimore City, but only 66 around the state. But that rule provides for an expedited hearing. It doesn't put specific numbers like 10 days,
Right.
which is totally unworkable.
Right.
But it does put it on an expedited track for the judiciary to address this situation in situations like the need for discharge from the hospital. So there is at least one option that has been enacted by the judiciary through a rule in 2019 that doesn't appear to be being employed very much. But putting that aside, even if there's problems with that, I think the federal grant is one in which the judiciary, which intends to bring all the stakeholders together. That is the purpose of it. The purpose is to bring the stakeholders together to see if we can find some alternatives to using guardianship as some kind of discharge plan. That's what we're working on. And we're happy to provide you what the status is, what the issues are that we're addressing, and what solutions that we are looking at. I'm not personally on that group, so I can't tell you in testimony today, but I'm happy to provide the committee with information about that project. But that's kind of the place that we ought to be
So
focusing
just to
on.
clarify, and then, I just want to clarify that you can follow up in more detail in writing. The judiciary has created a rule that allows for an expedited guardianship process in connection with medical treatment. So a very narrow, not a whole person, whole property, which is why it takes forever, but a very narrow for just this narrow purpose of medical treatment. And that's why if you narrow it very much, you can maybe expedite the
You can
process.
expedite
That's
it somewhat,
the
but
idea of it.
That is correct. I'm
Okay,
sorry.
that's
I'm
all.
sorry to interrupt you, but I
Mhm.
mean, yes, it is to expedite it. It is for that limited purpose, but it is a general guardianship of the person. It is not, it still gets you into a guardianship of the person.
Well, it's almost, I don't know why we don't have an expedited process for maybe some kind of limited power of attorney to make this decision. I don't know why you need a guardianship. We'll
Well,
talk about that later, but maybe that's what you're coming up with.
That's what hopefully we would be coming up with.
Great, thank you.
Thank you, Judge. Let's do one question, one answer. So I think that unless, all right. Thank you so much to this panel. I appreciate it. Thank you, Madam Magistrate. We'll now move on to the next opposition panel. Tammy Bresnahan, Carol Leanhart, and Randy Ames.
Do you want me to go? I'm here, right? Good afternoon, Mr. Chair and members of the Senate Judicial Proceedings Committee. I'm Tammy Bresnahan. I'm the Senior Director of Advocacy for AARP Maryland. We do have an unfavorable in on Senate Bill 759. I'm sure you've heard it all before. I'm sorry I missed it. I was in the House for a little bit. But ARP believes that policymakers should encourage less restrictive alternatives to guardianship when appropriate. Sometimes when you're in the hospital, and I know a little bit about this subject because when I worked for the government in 2011, one of your colleagues, Senator Roby, put a bill in about expedited guardianship. And it turned into JCR language, and I was the staff at the Department of Human Services that put together the hospitals, the judiciary, the Department of Human Services, the AAAs, and we issued a 152-page report. You can find that through the Maryland Legislative Information System. And we hired a consultant to help us with that. And the bottom line was that they didn't see a need for expedited guardianship. We know that you will make the best decision. It pains us to have an unfavorable, but just because you're old or because you're disabled or because you're homeless or because you have a drug addiction doesn't necessarily mean you need a guardian. We think the court system has handled this area very well, and we would respectfully ask you for an unfavorable report. Thank you.
Good afternoon. Good afternoon, committee members. My name is Randy Ames. I'm here on behalf of the Developmental Disabilities Coalition, as well as Disability Rights Maryland, the state's protection and advocacy agency for people with disabilities. Guardianship is not a discharge plan. People awaiting discharge from healthcare settings need more affordable, accessible housing and more access to the Medicaid home and community-based services. The fiscal note for Senate Bill 759 estimates a cost of $500,000. That money could be better appropriated to expanding affordable housing and serving those 20,000 people on the Medicaid wait lists. I'd like to share two case highlights that I think exemplify this problem that we're discussing here today. Disability Rights Maryland is currently in litigation with DHS and the Department of Health over foster children stuck in hospitals. This is an equivalent to this situation. Those foster children have decision makers. They don't have access to services in the community, and that's why they're stuck. Similarly, we currently have a client who has been receiving services through the Developmental Disabilities Administration since 1991. He has no family. He does not have the ability to give consent. However, he has staff and a coordinator that's been working with him since 1999 or 1991. However, rather than accept the consent of his provider, his community provider and case manager, as is permitted under Health General 5-605, which allows for surrogate decision makers, that hospital pursued guardianship. That person has been medically ready for discharge since January 9th. So I understand the hospital's concern about overstays, but this is a much more complex situation and problem that unfortunately Senate Bill 759 just doesn't address fully. And for those reasons, we oppose this bill and ask for an unfavorable report. Thank you.
Good afternoon to all of you. My name is Carol Leinhard, and I am the retired director of the Harford County Office on Aging. I'm the past president of the Maryland Association of Area Agencies on Aging, and currently I serve as the co-chair for the Maryland Senior Citizens Action Network. I'd like to acknowledge my senator, Senator James, Harford County Senator. I'm here, you have my written testimony in your file. I don't want to spend any time on that, but what I want to talk about is what it's like for us on the front lines dealing with guardianship. And I appreciate the fact that we're actually talking about doing something else, something more effective than guardianship. But think about it this way. I'm the director of the Harford County Office on Aging. I retired 18 years ago. At the time that I was serving, I had 11 guardianship wards. And I always treated them as though they were members of my own family. So that meant that I had 11 mothers. Now today, the director of the Harford County Office on Aging has 48 guardian wards. That means she has 48 mothers. She has 2 people to assist her with 48 wards. I had 1 person to assist me with 11. So she has 5 times the load, hardly any more help. And this is really a serious problem for those on the front lines of this case. And I'm aware, and I had shared with Senator James, the study that's out. We really believe that more needs to be concerned. I share with you the issue of where do these people go? When my husband had a cerebral hemorrhage a few years ago, he was in intensive care for 8 weeks. Then he went to something called step down. So that was less intensive. Then they moved him to a rehab facility. So we need to have some sort of levels of care where we can, allow these folks as much, I guess, autonomy as possible. Amen. I'm going to shut up, but thank you very much for listening and to understanding.
Well done. Seeing no questions for this panel, we'll next move to our virtual testimony. Barrett King, looks like you're here with us, and Heng Tan is next. Mr. King, please unmute yourself and you're good to go.
Thank you. Good afternoon, Chair, Vice Chair, and members. My name is Barrett King. I'm an attorney in private practice
primarily focused on representing alleged disabled persons and adult guardianships like the subject this afternoon. The bill states that if the purpose for seeking a guardian is for discharge or transfer from a hospital, the court shall hear and rule on that petition within 10 calendar days. And this is a petition for full guardianship, not just a limited scope discharge. The alleged disabled person would face a petition filed, for example, on the first of the month and risk losing their right of self-determination at the latest on the 11th. This prevents an alleged disabled and her counsel from fully exploring the case, perpetuating evidence in her defense. We couldn't even engage in full written discovery if we chose to in that time frame. Subpoenas would be difficult to serve to secure witnesses' testimony at these hearings. The proposed changes expressly state that the rights granted an alleged disabled are satisfied if that person is given the opportunity to be present, to present evidence, and cross-examine witnesses virtually. Absent from this proposed change is an acknowledgement that these cases shall be heard by a jury unless the right to a jury is waived. An opportunity is worthless if there's not sufficient time given to prepare that case, as I state. The right to an in-person rather than a virtual hearing is limited to a request by the petitioner or the alleged disabled. The proponent would have this bill not just allow virtual hearings, but require them. And as Magistrate Walsh testified, access to internet is something that many people don't face or don't possess. Those of us who have relative privilege may not realize that, but that remains an issue for many folks. And for these reasons, I would strongly urge the committee to make an unfavorable report on this bill. Thank you.
Thank you, Ms. Tan, I'm sorry.
Good afternoon. Thank you for the opportunity to address you today on behalf of the Baltimore City Administration. My name is Hyung Tan, and I have the privilege of serving as Deputy Commissioner at the Baltimore City Health Department and as the Area Agency on Aging Director for Baltimore City. You have our written testimony on record opposing Senate Bill 759, and I want to respectfully highlight our concerns. As the Area Agency on Aging Director for Baltimore City, I'm the court-appointed guardian for city residents age 65 and over who lack family or friends to fulfill this role. Among the many responsibilities I hold at the department, being the public guardian of last resort is one of the most serious and crucial roles I hold, and it does keep me up at night. Our agency operates the largest public guardianship program in the state with over 180 disabled persons. Being placed in a public guardianship program is a lonely and disorienting experience for the individual, and we firmly believe in aging in place with dignity and choice, and that care should be provided by family whenever possible. Thus, our team dedicates 40% of our time to look for alternatives for public guardianship. An expedited public guardianship process of 10 days would further overwhelm our system and hinder our ability to explore these alternatives effectively. We need time to locate family members, negotiate potential guardianships, and ensure financial arrangements are in place through a guardianship of the property. Rushing this process compromises the right and autonomy of disabled persons and strains our already limited resources. Public guardianship programs are already operating at full capacity, with Baltimore City bearing the disproportionate burden. We receive $170,000 in state funds per year to care for 180 wards, and are already handling 75% of the expedited petitions in the state. With that said, we are already seeing trends whereas petitions are being transferred to the city due to our greater availability of affordable housing and placement options. This bill would further risk overwhelming our city and forcibly uprooting individuals from their communities, depriving of their home and community support networks. Senate Bill 759 jeopardizes the well-being and autonomy of vulnerable individuals and places undue strain on our agency.
Ms. Tan.
We urge you to consider the implications and respectfully request an unfavorable report.
Thank you, Ms. Tan. Thank you, Mr. King. Any questions for our virtual witnesses? All right, seeing no questions, that completes the hearing for Senate Bill 759. Senator Charles, if you're ready, Senator Charles Day has begun.
Way too many bills. I've learned my lesson. All right, it's a great bill, bad number. If you got a chance to look at this number on the bill. Yeah. Good Good afternoon, Vice Chair Wall Striker and honorable members of the committee. Thank you for the opportunity to present Senate Bill 666, Human Relations Discrimination by a Place of Public Accommodation. This piece of legislation empowers individuals who have faced discrimination within public accommodations such as restaurants, retailers, and entertainment centers by providing them with pathways to seek monetary relief after undergoing the complaint process by the Maryland Commission on Civil Rights. It seeks to rectify injustices faced by individuals and ensure that everyone can access public spaces without fear of discrimination or bias. People with physical challenges often face barriers to being able to have the full experience of going to see a movie in the theater, have a meal in a restaurant, shop in a retail store, or even present at a committee hearing, which we have seen happen. Many times it takes small accommodations to allow them to share the enjoyment or full engagement of these activities. When those accommodations are deliberately and intentionally denied, that is blatant injustice. This committee has seen the concept of this bill several times over the last 13 years. This session, we started out with the original 2011 version of the bill. However, we have brought multiple stakeholders to the table and amended the bill back to the posture that the House passed back in 2020 of March. This proposed language maintains the current process. When a victim of discrimination chooses to go through the MCCR complaint process, the commission completes a full investigation first. If they find cause, they will look to see if the respondent has made good faith attempts to mitigate the issue and then try to mediate it to resolution. If they find both fault and no mitigating circumstances and no efforts to resolve the issue, the commission will send it to an administrative law judge with a recommendation. The ALJ considers all the facts in the complaint, the findings of the MCCR, and its recommendations. The ALJ may award monetary relief to victims based on several factors, including the seriousness of discriminatory act, the good faith of the respondent, and the respondent's assets. One question that is frequently asked is that what constitutes a good faith effort if an employee commits this discriminatory act? This could be as simple as an apology, some appropriate training, or a day of suspension. We trust the MCCR will handle the cases with careful consideration and have a full grasp on what will constitute a good faith effort. The MCCR is a great resource to our state in addressing the extremely sensitive issue of discrimination, but we have tied their hands as far as remedies for proven bad acts. Please provide them with this tool that they need to enforce our commitment to an inclusive and diverse society in which everyone is valued. As mentioned, I have an amendment, and I don't know if I should offer it now or we can deal with this later in committee, but there is an amendment to the bill. And with all that in mind, I urge a favorable report, and I'll ask for my my panel to come up. Stand by.
Ms. Hughes, Mr. Williamson.
Good afternoon, Mr. Chair and Mr. Vice Chair and members of the committee. My name is Glendora Hughes. I'm General Counsel of the Maryland Commission on Civil Rights. I'm here to testify in support of a favorable report for Senate Bill 666 as amended. The Maryland Commission on Civil Rights is responsible for enforcing the state anti-discrimination law, in particular, in this case, the public accommodations law. This particular bill is going to provide some sense of relief or a monetary relief to a person who is a victim of discrimination in public accommodations. Presently, there is no relief remedy for an individual other than a civil penalty, which goes into the state's coffer and not to the victim of discrimination. And perhaps they may get a letter of apology. Presently, this is the weakest part of our law in comparison to employment and housing. And this is a modest bill to provide some sort of relief for those who have proven and established that a discriminatory act has taken place and that the person has suffered harm and shows that what harm they have suffered. And for these reasons, we ask that there be a favorable report in support of Senate Bill 666. Thank you.
Good afternoon, and thank you for your time. My name is Sam Williamson. I'm a staff attorney at Disability Rights Maryland. DRM is the protection and advocacy organization for the state of Maryland. Discrimination by places of public accommodation continues to isolate and harm those with disabilities. DRM represented a child who was rejected from a camp because the child needed anti-seizure medication. The camp refused to provide any reasonable accommodations and told the family they would need to find another camp. The family was unable to find a place, and the child was unable to join their peers. Having the remedies provided by this bill could help families like this one better afford childcare if a camp refuses to enroll their child, or perhaps pay for a more expensive camp that will provide reasonable accommodations. This type of discrimination occurs across many different types of public places, from a fast food drive-through where workers refuse to take a written food order from a deaf customer, to public buses where a bus driver stopped announcing bus stops to a blind passenger who was trying to go home from church. The passenger rode all the way to the end of the line and had to backtrack to get home. This bill will not only help address the harms that people with disabilities experience, it will help prevent these harms from happening in the first place by providing an incentive to comply with Maryland's anti-discrimination laws. I urge you to issue a favorable report just as the House committee did. Thank you.
Senator Muse.
Senator Charles, you don't have to get up. This is a quick, I understand both sides of the issue and I support your bill 100%. Problem is I can't touch anything that has 666 on it. I mean, certain look at it, I'm just kidding.
Tough bill number. Luck of the draw, I
It's like,
guess.
it's like the 13th floor. We should just kind of skip over it next time. No one gets this bill number. Senator West.
Thank you, Mr. Chair. When I was in the House, the fellow who sat next to me, then Delegate Christian Mealy, had a bill dealing with death, and it happened to be assigned 666. So, two comments. First, I'm just stunned that this is not already part of Maryland law. I wonder how in the world, in all these decades since the 60s, we have not added public accommodations to something which the Civil Rights Commission can attack. So congratulations, kudos on recognizing this omission and trying to add it to the statute. Second, though, there's some suggestions that the bill should be amended to conform it to House Bill 368. I assume that's what your amendment does?
It does.
Great. Okay. No further questions. Thank you.
Thank you to our panel and to the sponsor. We'll now move to the opponent, Mr. Melvin Thompson, Restaurant Association of Maryland. Mr. Thompson.
Thank you very much, Mr. Vice Chair, members of the committee. I'm Melvin Thompson. I represent the Restaurant Association of Maryland, and our opposition is only to the bill language as introduced. We've worked very closely with the cross-file House sponsor on this bill. Our amendments have been adopted, and that takes the bill back to the posture it was in 2020 when we did not oppose the bill. Senator Charles is absolutely right. We've been working on this issue since 2011. We have finally reached a place where we're not opposed to the bill, and we would encourage you to consider those amendments to replace this language as a substitute. Thank you very much. We would withdraw our opposition then. Thank you.
All right. Kumbaya on 666. All right. Thank you, Senator Charles, for bringing the bill. Thank you, Mr. Thompson. That completes the hearing on Senate Bill 666. We'll now move on to Senate Bill 669. Senator Charles.
As you can see, I dropped a whole bunch of bills at the same time, so you can see the numbering schematics. This bill came from the Attorney General's office, and I think I should have somebody from their panel here. Good afternoon, Vice Chair Wallstreich and honorable members of the JPR Committee. For the record, I'm Senator Nick Charles, testifying in support of Senate Bill 669. This bill is very simple and repeals the provision of the Office of the Attorney General must report annually to the governor and to the Legislative Policy Committee on any action taken under the Maryland Defense Act regarding the investigation, prosecution, or defense against any action or inaction by the federal government that threatens the public interest and welfare of the state's residents, and then publish their findings in a bound volume. By repealing the mandate for the Attorney General to annually report actions taken under the Maryland Defense Act to the governor, the Legislative Policy Committee, this bill reduces administrative burdens without compromising transparency or accountability, freeing up an essential 80 hours of staff time per year. Additionally, the bill modernizes how the information is provided to the public by transitioning from the traditional bound volumes to online publications of the Attorney General's annual reports. This shift to digital enhances accessibility for the public, ensuring that citizens can easily access important governmental documents and decrease the publication and printing of outdated bound volumes. We have Mr. Patrick Hughes from the Office of the Attorney General. Should you have any questions, and I urge a favorable report. Thank you.
Thank you. Both of our witnesses are virtual. Let's take them and then we'll circle back for questions. Mr. Hughes, you're up. And Ms. Cross, you are next.
Thank you, Mr. Vice Chair, members of the committee. My name is Patrick Hughes. I'm the Chief Counsel of Opinions and Advice with the Office of the Attorney General. As the sponsor explained, this bill would amend 2 of the reporting requirements for OAG. I'm here primarily to talk about the second, the requirement that the office's annual report be published in a bound volume, along with the official opinions of the Attorney General from the preceding year. In today's digital day and age, it's no longer necessary to publish the annual reports of the AG in bound volumes. Instead, it makes more sense and would save taxpayer dollars to simply publish each annual report online. To be clear, the office does intend to continue publishing bound volumes of its official opinions, not the annual reports, but the deletion of the express publication requirement for both will provide the office with greater flexibility in terms of how often to publish the bound volumes and how many are really needed to publish. And in between the publication of each bound volume of official opinions, as has long been the case, the office will continue to post the opinions on its website so the public can have immediate access to them. That briefly, the other reporting requirement the bill deals with is the Maryland Defense Act report. As explained in our office's written testimony, that report takes about 80 hours of staff time per year to complete, time that could instead be used litigating cases on behalf of Marylanders. In sum, the Office of the Attorney General urges a favorable report on SB 669. Thank you.
Thank you, Mr. Hughes. Mr. Hughes, I was wondering if you could spend some time and opine on the constitutionality of, no, I'm just joking. You right. So just some quick legislative history on this bill. This bill comes out of the previous presidency, and I think we should be aware that the same candidate is a candidate again as we consider this bill. Let's go. Is Ms. Cross in the waiting room? Yep. Let's go to Ms. Cross, and then we will take questions. Ms. Cross, you're up.
Thank you, Chairman, and thank you so much to the Senator for bringing this board, the Senate Bill 669. We are grateful as a community for transparency when it comes down to the Attorney General's reports. I am grateful again with only one amendment that I would recommend, that with this age of cyber crimes and cyber espionage, that also be included in the actual bound. I understand that bound takes a lot of time and a lot of energy, but I cannot express enough how much of our senior citizens depend on these bound volumes. And not only that, but every year as the mayor of City of Glenarden, I pick up my bound volume because it's always a successful reference tool on how we have progressed and how we have changed, how we have regressed, and how we have grown. Absent of presidency, transparency is a right, constitutional right for the people. And when we are a government that serves the people, of the people, for the people, it's not about a body in as much it is about the full transparency of the operational statutes of the government in which we, as the residents of the community and of the state, do depend on. When we are guarding against fraud, we have senior citizens who are still falling prey to fraud. These reports give us adequate information relative to the latest attacks and what types of things that were things that they should have been paying attention to, helps us train and educate on financial stewardship as well relative to the findings of the Attorney General's office. This office is critical and it's invaluable in that it intends to bring suit. And I also would add that the governor, while seems to have a veto authority, the amendment would be that the governor can also bring suit. Thank you so much for this bill.
Thank you, Madam Mayor. Questions for our virtual panel or for the sponsor on SB 669? All right. Seeing no questions, thank you, Senator. Thank you for bringing the bill. Thank you, Mr. Hughes, and thank you, Mayor Cross. That completes the hearing on Senate Bill 669. Senator Charles will next move to your bill, Senate Bill 670.
2 down, 3 more to go. All right. For the record, I'm Senator Nick Charles, testifying in support of Senate Bill 670. I briefly previewed this bill last week when we heard Senate Bill 663, the rebuttable presumption bill. Senate Bill 670 mandates that the courts consider a comprehensive range of factors in determining custody and visitation arrangements, ensuring that decisions are made with the child's developmental needs and overall welfare at the forefront. By requiring the court to consider each of the factors outlined, this bill establishes a comprehensive framework for safeguarding children's interests. By requiring the court to articulate each factor and the weight given to each factor on record, we hold our courts to a higher standard and ensure that parents understand exactly what contributed to the decision that was made. Moreover, Senate Bill 670 emphasizes the importance of maintaining a meaningful relationship between the child and both parties, siblings, and other relatives, recognizing the vital role that familial connections play in a child's upbringing and well-being. Additionally, the bill addresses issues such as domestic violence, abuse, neglect, military deployments, ensuring that these factors are appropriately considered in custody determinations to safeguard children from harm and trauma. I have witnessed firsthand the profound impact that custody and visitation decisions can have on children and families. With this bill, we will ensure that any parent preparing to undergo this often difficult process are able to know exactly what will be considered by the court before proceedings begin. The Maryland Bar Association states it perfectly in their informational letter when they state, currently, judicial determinations regarding child custody are made based on factors set forth in several Maryland appellate cases. In order to know what testimony and evidence to present to a court in support of a claim for custody, a litigant has to identify the correct appellate decisions and be able to distill the legal holdings of each case and correctly apply those holdings to the factors of their own case. While this may be fairly straightforward for experienced family law attorneys, most underrepresented non-lawyer parents would find this to be a Herculean task. Furthermore, the seminal appellate decisions are decades old and not necessarily reflective of today's families and the modern demands of parenting. This contributes to the fairness of proceedings and all of the overall knowledge that all parties will have before defending themselves to have access to their children. Senate Bill 670 underscores a worthwhile step in promoting fair, equitable, child-centered outcomes in family court proceedings. I urge the committee to support this important piece of legislation and prioritize the best interests of Maryland's children. I urge a favorable report and thank you all for your commitment to improving the lives of children and families in our state.
Thank you, Senator Charles. Questions for the sponsor on this bill? All right, thank you for bringing the bill. We'll now move to the opposition, which is virtual. Vince McAvoy joining us online.
You're muted, Vince.
Vince, it's been a while.
Hello, Senator. Nice to see you.
Great.
Nice to see you. Thank you so much.
Go ahead.
All right. I appreciate your time, committee. Thank you so much. Senator Charles, boy, we met a long time ago. Senator Nick Charles, I know I'm late on this, but let me welcome you both to the Senate and the JPR. Congratulations. I appreciate the courtesy of you reaching out on this bill, Senator. I am against this. This is something of a rehash from Delegate DeMay, and something caught me when you started this issue. When you're talking about defending ourselves, this is not the stance that parents should be in. We have parental rights. The equity court is meant to step in for parens patriae, and that does get to sort of the heart of this bill, where it is couched in 9101 and the other parts that you open with and reference in page 3 as well, back to a stance of domestic violence, of some type of hazard to the child. And that is simply not the actual reflection of most custody cases. Yet it is why that we have these situations where domestic violence pros come in and assert themselves as basically saying that we start off parenting arrangements with a 0 to 0 percentage. This is wrong. Your bill on rebuttable presumption last week got it right. We should defer to that. But I do want to talk about a couple of particulars as I know time is running out. When we talk about protecting the child from adverse effects of any conflict from the parties, can we do this? Do we raise our children in bubbles? I know that in Baltimore, we have carjackings up 500%. Our children are facing unconscionable dangers. But to have parents who are having arguments in these hard times, that is not an abnormality, nor should it be a demerit. I also want to I hear the bell. I just want to close by saying that we have had attempts to get the courts to recognize parental alienation and contempt. Our courts don't do that. I am available for questions. Thank you, Senators.
Thank you. Any questions for Mr. McAvoy? All right, seeing no questions, thank you, Senator Charles, for bringing the bill. We appreciate it. That concludes the hearing on Senate Bill 670. We'll now move to Senate Bill 671. Senator Charles, if you want to bring up your panel, you are welcome to do so.
Thank you so much. So I'm going to ask that Jessica Nkosa from Community Legal Services for Prince George's County comes up. William Steinwhittle from Maryland Legal Aid Bureau. Michelle Siri from Maryland Legal Services Corporation. She's caught up over in the House right now. It's about 40 people testifying, which is dragging things out. All right. Thank you guys for being here. All right. Good afternoon, Vice Chair Wallstreich and honorable members of the committee. Thank you for this opportunity to present Senate Bill 671, Foreclosure Proceedings, Residential Mortgages, and Grantors Access to Counsel. Homeownership, revered as the hallmark of the American dream, is hindered by systemic obstacles deeply rooted in historic discriminatory practices such as redlining and biased mortgage lending. Research that was done in 2022 highlights stark racial disparities, with Black borrowers facing a denial rate of 27.1% compared to 13.6% for white borrowers. Recognizing the unfortunate trends in neighborhoods resembling my own, I collaborated with institutions such as the Brookings Institute, Ashoka, to craft legislation aimed at empowering not only Black homeowners, but also low-income families. Senate Bill 671 comes as a crucial component of one of these comprehensive strategies. Foreclosure. It is a catastrophic event with tremendous consequences for the future financial stability and social mobility of affected families. Our goal in the state of Maryland should be keeping Marylanders in the home they had to work so hard to get. Senate Bill 671 aids this by ensuring access to legal representation for individuals meeting specified qualifications in foreclosure proceedings. Those qualifications include someone who owns a residential property and earns less than 50% of the state's median income, providing a lifeline to those on the brink of displacement. To facilitate this access, the bill establishes the Access to Counsel in Foreclosure Proceedings, ACFP program, overseen by Maryland Legal Services Corporation. Tasked with organizing and directing services and resources, this program is designed to provide all of the eligible individuals with access to high-quality legal representation. Furthermore, this bill establishes an ACFP task force and a dedicated special fund, both under the purview of MLSC, to ensure effective implementation and sustained support for vulnerable homeowners. By passing Senate Bill 671, we are taking a collective stride towards nurturing generational wealth development in our Black communities and providing vital assistance to low-income families grappling with housing insecurity. This opposition to the bill will say that the state of Maryland already provides countless resources to those going through foreclosure proceedings. However, we must face the reality that even the maximum amount of preparation can leave a homeowner understandably stressed and perplexed in navigating a foreclosure situation. These complexities are guaranteed to be heightened once they go through the actual proceedings. With all that in mind, I urge a favorable report and I'd like to say thank you. And I'll pass it on to Jessica.
Sure. Good afternoon, Vice Chair and committee members. My name is Jessica Kinkosa. I'm the Executive Director of Community Legal Services of Prince George's County. I want to thank you for the opportunity to testify in support of SB 671, a bill that would allow homeowners to receive access to counsel foreclosure proceedings. CLS is a nonprofit organization established to provide quality legal services to low-income residents of Prince George's County and surrounding counties. We provide advice and representation to homeowners facing foreclosure since 2008. And we've been a leading resource to help residents avoid foreclosure. During the 2008 foreclosure crisis, the legislature enacted laws to improve foreclosures and allow homeowners meaningful opportunities to receive notices of the foreclosure in hopes that it would improve the foreclosure process. These laws, while helpful, are still not enough to assist all homeowners facing the loss of their homes. Post-pandemic, homeowners across the state face additional challenges limiting meaningful participation in the foreclosure process. The challenges under Maryland law include numerous technical pitfalls in the normal judicial process, which can lead a summary denial of the homeowners' arguments, silencing their voices. The technical expertise to be heard is too often dependent on funding an attorney to plead for the homeowner. SB 671 will remedy this problem because it will put in place a mechanism for Maryland homeowners to prepay into a fund for a possible future need to save their home from foreclosure. This process is akin to paying title insurance. SB 671 establishes a right to representation in foreclosure cases and provides the funding that will allow a homeowner's fair chance of working with their lenders and the courts to preserve home ownership. SB 671 will accomplish this by improving the number of performing loans by allowing homeowners guidance within the foreclosure process to help them take advantage of the tools that are in place to keep them in their homes. It's ultimately beneficial for lenders and communities as well. Lenders know that foreclosed loans are less profitable than performing loans. Foreclosed homes also impact the community and lower the value of homes surrounding a foreclosed property. SB 671 will improve communities and will help maintain generational wealth by preserving homeownership. We urge a favorable report.
Thank you, Ms. Kinkosa.
Hello, Chair, Vice Chair, the Judicial Proceedings Committee. My name is William Steinwhittle, and I'm the supervising attorney for the Foreclosure Legal Assistance Project of the Maryland Legal Aid Bureau. This bill is very personal to me. I spent the last 10 years representing homeowners in bankruptcy and foreclosure mediation and other litigation to prevent foreclosure. I published a op-ed in the Baltimore Banner on February 2nd. Foreclosure is still a major problem, despite what you have heard about how the economy is rolling at this point. The Homeowners Assistance Fund has ended. There is no more further assistance provided. And loan modifications and bankruptcies are harder to get than ever. The reason is that because of the home equity exemption in Maryland being limited, a Chapter 13 is extremely unaffordable for most homeowners, especially low-income homeowners. In addition, loan modifications are especially hard to get due to the fact that the interest rates are much higher than they were when the loans were originated a decade or a half a decade ago. In addition, the mediation process that was created by the foreclosure task force in 2010 is extremely helpful. However, it can be very confusing for homeowners. I receive calls on nearly a weekly basis where a homeowner believes that there was a resolution in the mediation, but the house was sold anyway. So it is extremely helpful for these people to have counsel, as this would prevent this from happening. Most importantly, a homeowner who does not have counsel, who cannot find counsel, is not going to simply just decide to roll with it themselves. They are going to look in other places, and unfortunately, this leads to many scammers taking advantage of low-income homeowners by saying that they can offer them foreclosure help when they are just taking their money. If you need any further details, please look at a case where I represented a client to get the money back that he lost, trying to seek foreclosure assistance, and it is under the name Synergy Law. They have now been indicted by the FBI. So this is what happens when you do not have an access to counsel in a foreclosure case. Thank you very much.
All right, question for the proponents of the bill or the sponsor, Senator West.
Thank you, Mr. Chair. So I've for a long time been a member of the Access to Justice Commission, and I'm totally in favor of the concept of providing legal counsel for people who are involved in foreclosure proceedings. We did that a couple of years ago, maybe 2 years ago, 3 years ago, to people involved in evictions. And this is sort of the same idea. But the problem I have with this bill is the funding. So could I talk to the sponsor of the bill for a moment? So are you aware that the average sale of a house in Maryland is $410,000? That's the median sale price. So as I see the numbers in your bill, it means that if this house sells for $500,000 or more, and since the median price is $410,000, probably 40% of the homes in Maryland are sold for $500,000 or more, that they're going to be taxed now, have an additional tax of $250 when they sell their house, correct?
Correct.
So we already have lots of different fees imposed on people who sell their houses. We've got 2 transfer taxes, we have a recordation tax, we have a recording fee, we have property taxes. In some counties, they have extra property taxes. So this would add an extra $250 on the sale of the house. Does that bother you at all?
You know, I try to think about it from the perspective, $250, and this is for you as a homeowner. You don't know what your future holds. You have no idea that 5 years or 10 years down the line, you're going to run into a financial obstacle that's going to put you in a position where you could possibly lose the house that you saved all of this money for. You've done all of this work to put yourself into a home to make life better for your families. But $250 at the forefront of all of this, if you end up running into a problem, you have access to counsel. And so I think when you look at it from a holistic approach, I think the $250 early on when you're purchasing a house, I think that is, I think it's something that it's not too far-fetched. It's not $1,000, it's not $2,500. I probably would feel a certain type of way if I saw a $2,500 bill on me purchasing my home, but $250, I don't think that's something that will have a long-lasting impact when you're looking to protect yourself later on down the line in the future.
Okay, well, you hit on another issue, and that is there's nothing in your bill that I can see that specifies which party to the sale is going to pay the $250. Would this be the seller or the buyer?
To my understanding, it's the buyer, and we can work through any particular changes if I think you want to add some amendments to it. I don't mind if it's the seller or the buyer, but I think it should be the buyer that has to pay this $250 because they'll be the one who actually benefits from this.
So how were these numbers arrived at? The fees?
It was a combination of conversations with Maryland Legal Aid, CLS, MLSC. It's a lot of conversations going back and forth. What was it? Last year we put this bill in, and a part of the conversations was how do we come up with fees to pay for this, and this was something that was generated out of mutual conversation.
What was the estimate of how much money will be needed to pay for free legal counsel for people who couldn't afford it in foreclosure houses?
I'm not sure of the answer of that one, but I can get you an answer.
Okay, because I've see a computation here suggesting that last year, if this bill had been in effect, it would have raised $6,357,000. Is it really going to cost over $6 million to compensate pro bono counsel in these cases? How many foreclosure cases do we have that require counsel?
We had this last year.
Total for, I want to see, I can look it up.
Yeah.
Give me 1 second.
Yeah, she's gonna look up the total amount of foreclosure cases that we had. Listen, in Prince George's County, we have a judge just dedicated specifically to foreclosures because it's a real issue.
Well, of course, the state taxpayers pay for the judge.
Right, exactly. But to my point, they have a judge that's specifically set aside to handle these issues because it is a real issue and you have multiple people going through these problems. So there are a lot of foreclosure cases. The $6 million paying towards organizations like Maryland Legal Aid, paying for organizations like MLSC, paying for organizations like Prince George's County Community Legal Services. It puts them in a position that they can actually step up to the table and help a lot of these organizations. We're talking statewide, so $6 million isn't a lot of money when you start looking at it from a statewide perspective.
Okay, final question. Would you be willing to entertain an amendment to your bill which would take out this particular funding regime and instead require the state to pay for the counsel?
We can have some more discussion, and I think we'll bring the other folks to the table. But I'm always willing to entertain amendments as long as it makes sense for all parties at the table.
Great, thank you.
And we'll get you that information when Jessica finds it for the total amount of foreclosures as well.
I'll keep looking for it. I'm going through MLSC's annual report.
Okay.
All right. Further questions from committee? Seeing none. Thank you very much. Thank you. All right.
I knew Chris was Senator West was gonna have some good questions for me, man. I've been waiting, man. I've been waiting for it.
Okay, excellent. So we're done with that concludes the testimony for the proponents of the bill. I think we have favorable with amendments.
Yes.
So we've got joining us virtually is Brendan McKay and Ms. Cross. Brendan, you're up. Welcome.
Oh, thank you very much. Thank you. Sorry. Thank you, Senator Charles, for introducing this bill, and thank you for to the committee for hearing it. And I also wanted to thank Senator Waldstreicher. He is my representative, and me and my neighbors very much appreciate the work you're doing to represent us. I am a mortgage broker out of Bethesda, Maryland. I'm also on the legislative committee for the Maryland Mortgage Bankers and Brokers Association, and we wholeheartedly support the intent of SB 671. And believe that everyone should have access to proper legal representation when it comes to presenting something as important to their home. But the issue we take is with the funding mechanism of the bill. So we are, supporting it with amendment, asking that be reconsidered. This entire country has a housing affordability crisis, and Maryland is not exempt from it. Homes are too expensive and they're too difficult to get into. It requires too much liquidity to get into. And in addition to having a housing affordability crisis, we also have a competitive problem with our neighbors in Virginia. Maryland closing costs are already significantly higher than they are in Virginia. On a $500,000 home, transfer and recordation taxes in Virginia would be about $3,000, and in Maryland, they're $7,400. So any incremental increase of closing costs is going to exacerbate that problem. And the funding mechanism for the resources provided in this bill would be blanket closing cost increase on all transactions in Maryland, which is problematic from our perspective. We're really past the point of calling it a slippery slope. We need to be doing work to reduce the cost of becoming a homeowner in Maryland, not increasing it. So while we completely support the intent of this bill, we'd love to find if another funding mechanism for it could be found. So thank you again. And
Excellent. Thank you very much. All right, do you want to do one more and then for the virtual, we have 2 virtual and then I'll get you. All right, excellent. Thank you, Mr. McKay. We've got one question for you, but we're going to take one more panelist virtually first and then we'll come back to you. So Ms. Cross, if you are up and ready, you're up.
Hello, thank you so much. Are you?
Hey, there you go. I think you're unmuted now and ready to go.
All right, super, thank you. We do support favorably with amendments for Senate Bill 671. For Senate Bill 671, we do acknowledge the purposes of establishing access to counsel, which I do believe in a foreclosure proceeding is already a stressful enough time. Any special fund should be set aside for ensuring that those that are unfortunately having to meet this circumstance will have the appropriate care and community support relative to what is probably going to be, a homeless situation. Foreclosure proceedings are never easy. What I do note is that it is a financial establishment that has to be put in place. But I do know that residential properties as the principal residence, as well as residential properties and the funds that we put aside, legal representation is quite expensive. It's not easy. And I believe that if we proceed with getting the most appropriate legal representation, that we would then have the most right support for the community. So with the amendment being the appropriate source in which to pull the funds, but I do support legal representation in the case of foreclosure. I've had at least 2 that I've had to unfortunately experience. They did not have money for legal representation. And as a result, the end game is always going to be in favor of the state. So I do thank you, Senator, for your concern and bringing this notice of intent forward. And thank you so much for favorable with amendments relative to the sourcing of the payments, not to raise other bill payments otherwise for homeowners. Thank you.
Excellent. Thank you very much, Mr. Cross and Mr. McKay. We've got Senator Muse has a question.
All right, first of all, I just want to say to Mayor Cross, hello, and she's doing a tremendous job in our county and in the city of Glenarden. Mr. McKay, just a simple question. I'll preface it by saying this: from what I can see, the total cost buying a home, et cetera, we're talking about $250. The average person may buy 3 houses in a lifetime. You're talking about $700. Is that really something that, there's got to be a way, and if there are other ways, I'm interested in your amendment. If you can send me your amendment, that's number 1. And number 2, in the larger scheme, every penny matters. But we pay more for homelessness than we would just paying a $250 to help with those legal fees. Does that does my way of thinking make sense?
Yeah, it absolutely does. And once again, we recognize this is an incredibly important issue. Like, people going through foreclosure should absolutely have as much representation as possible. As the mayor noted, it's an incredibly stressful time, and they should have any help available. But my concerns come from a place that we are improving a problem in one area and worsening one in another. And I'd love to see a solution where it didn't have to be such a push and pull. I'm not going to sit here and tell you I know what that funding mechanism should be. I'm not an expert on Maryland state economy, on how the government is funded well enough to know where the money might be. But I know that you are worsening a very serious problem. And while $250 is not a ton of money, like you said, every penny counts. And like, back to my comment about, we're well past the slippery slope point. If we were, kind of inching up towards it, and we weren't a $3,400 difference in closing costs between our neighbors in Virginia on the example I'd give, I'd be like, yeah, $250, whatever, no big deal. But that's a drastic difference. And people are already moving to the other side of the river over this issue. And every dollar that it goes in the wrong direction is going to worsen the problem further.
Okay, thank you. Thank you.
Yep.
Deserve it.
Excellent. Thank you very much, Senator. Further questions from the committee? All right, seeing none, that will conclude the hearing for Senate Bill Oh, I'm sorry.
That's
Hey,
my
hey,
position,
I'm sorry.
my
My
good
apologies.
friend.
Yeah.
Here to oppose
My
the bill.
bad. There you go. That'll conclude the testimony for the favorable with amendments. Now we'll move to the opposition panel. Mr. Enton.
Thank you. Mr. Chairman, members of the committee, Robert Enton on behalf of the Maryland Bankers Association. We have our written testimony, and I would really urge you to take a look at it. It's a very comprehensive analysis of the foreclosure process and statistics in the state of Maryland. We have probably the most successful and consumer-friendly foreclosure process in the entire country. And I say that, and I would urge you, if you turn to the second page of our written testimony, you can see the statistics. Statistics are as follows. The find what I did with them here. So if you look, what you're going to see is the notices of intent to foreclose. So for fiscal 2023, go back to fiscal year 2012, there were 178,000 notices of intent to foreclose. In fiscal year 23, there were 64,000. That's the notices that go out saying we intend to foreclose. When you drop down to the chart below that, what you're going to see is that the next notice that goes out is the notice of foreclosure, of actual foreclosure. You can't foreclose until 45 days have passed. That goes from 65,000 to 10,000. And the most telling number is when you look at that yellow line down there, you'll see the total number of properties that go to sale is 2,195 properties. And that's because we have a system that works, and it works well. When you look at the legal aid funding, we just think it's totally unnecessary. You look at the fiscal note, it says that this is going to increase the fees that go to legal aid by $19.9 million in fiscal year 25. When you look at the financial statement for legal aid, you'll see that they're sitting on $47.2 million in assets. I'll close by saying this. We just don't think it's necessary. I think the process works. It works tremendously well. And I went to the Department of Budget Management document that has the money that gets allocated to different things for the state. And under their special fund expenditures, and this is legislation that passed here, and I'll wrap up, Mr. Chairman, was $24,900,000 in 23, $27,224,000, and the appropriation that's scheduled for 25 is $35 million for legal aid. If they think they need to do this, they have adequate funding to do it. We don't need to increase closing costs.
Thank you very much. Thank you.
Sorry to go so long.
No, it's like he gets paid no matter how long or short it is. Okay, all right. Appreciate it. Thank you very much.
Thank you.
Questions from the committee? All right. Thank you very much. With that, that will end the hearing for Senate Bill 671. We'll now move on to Senator Charles with Senate Bill 668.
Maybe how we do it. On the front. All right. When you do bills with millennials over on the House side, you get props. So the good delegate Joe Vogel gave me some good props for this bill, which I think will allow for everybody to see this from a very clear, jarring perspective.
He must be running for Congress or something.
He must be. He must be. All right. Good afternoon, Chair Smith, Vice Chair Wallstriker, and the honorable members of the Judicial Proceedings Committee. For the record, I am Senator Nick Charles testifying in support of Senate Bill 668. You know, I grew up, my grandmother actually had a lot of kids that went through the foster care system, man. And every time a lot of these kids came to her house, they will be coming with black trash bags that resemble this picture right here. And the fact that that is how we're treating a lot of the children in our communities that are at the bottom of whatever the worst situation is, being removed from their families. I think that is a horrible experience they're already having to deal with, but bringing humanity to what they're going through by providing bags like this blue one behind it is very critical to making sure that we give these children the understanding that the state of Maryland actually loves and respects them. As you all know, I'm an incredibly proud father, and I know that many of you in this room consider yourselves remarkably lucky to raise amazing kids. The root of this bill is very simple, and that all children deserve to feel secure. It's disheartening to think that some children in our state are forced to pack their belongings in nothing more than a trash bag when moving from one foster home to another. Imagine if every time you moved or went on vacation, you gave your child a trash bag to pack their belongings in. That is what the state of Maryland is allowing for our children in the foster system. This heartbreaking reality highlights the need for change. The emotional turmoil these children experience, already grappling with the uncertainty of their circumstances, being handed a symbol of disposability, a trash bag, for their cherished possessions should make us all feel sick. This practice not only lacks compassion, but also strips these children of their dignity. That's why I'm supporting Senate Bill 668, a bill that puts an end to this practice. Senate Bill 668 will require the Department of Human Services to create and manage a decentralized supply of new luggage to be utilized by children experiencing foster care to transport their belongings. The department may solicit and accept grants, gifts, and donations of any kind to help them meet this requirement. And that right there, I think, is very critical when we're looking at the budget implications that we face as a state. They can accept gifts and donations to help close the gap. Senate Bill 668 ensures accountability by requiring the Department of Human Services to report any instances where a child is provided with a trash bag instead of a proper luggage to understand why a lapse may persist. This bill enacts meaningful change and helps to make sure that no child in our state is ever made to feel disposable. The fiscal note is minimal in comparison to the worth this will bring to Maryland's foster youth. I have an incredible group of people that's up here next to me on my panel, so I will turn it over to them. I have Miss Erica Lamone from Maryland Legal Aid. I have Dolores Sanchez, and I also have Miss Macy Wilson.
Is that okay, Mr. Chairman? Okay. All right. Good evening, Mr. Chairman, members of the committee. I'm usually Dolores Sanchez of Ficalche. I'm usually before you on behalf of clients, but today I'm here in my personal capacity as a former foster care youth. And I'm here in support of Senate Bill 668. Thank you very much, Senator, for introducing this important bill. I urge you to support this legislation. Luggage may seem like a trivial detail, but for a young person facing the upheaval of being removed from their home, it represents dignity, stability, and a sense of belonging. When a child must pack their belongings in a disposable trash bag, it sends a message that they are disposable and that they are not worthy of basic respect. I remember the embarrassment and shame I felt every time I walked into a new home with nothing but a trash bag. It reinforced feelings of worthlessness and invisibility that many foster children experience. By supporting this legislation, you have the power to make a meaningful difference in the lives of countless foster children. You have the opportunity to send a message of compassion and dignity, showing these vulnerable young people that they are valued and deserving of respect. Each time we had new young people come to my foster mother's house, we would know we were getting a new foster sister because there would be trash bags at the door. And this simply is not the way we should treat young people who are ward of the state in many cases. These are our young people. This is not how we should send them through the world. So these bags over here are collapsible. They're small. You'll notice in the bill that it does not have to be a suitcase. It can be a duffel bag. There's many different ways. It shouldn't take up too much space. So I do urge the committee support and appreciate your time this evening.
Good afternoon, Chairman Smith, Vice Chair Wallstreicher, and committee. Thank you so much, Senator Charles, for sponsoring this bill that serves to recognize the importance of standing up for the most vulnerable population in Maryland. Senate Bill 668 will assist in requiring the department to make sure that foster children or children in foster care are respected. This bill can improve the lives of the children we serve, children who, by no fault of their own, who have been abused, neglected, or have serious mental illnesses. These children are often overlooked, and their safety, needs, and well-being sometimes take a backseat to many people, including the parents who have abused and neglected them. Passing this bill contributes to letting them know that they matter, that they are important. Let's talk about a client we'll refer to as Javier. Javier is from Honduras and does not speak English. He left the Honduras because he watched the execution style killing of his father. He was also targeted and needed to flee. Unfortunately, he has also experienced significant trauma while in care. The photo that you have seen and that I provided in my testimony is his belongings. This photo was taken on January 16th after he was leaving a homeless shelter, a youth homeless shelter, where he was placed by the Prince George's County Department of Social Services. He has moved several times, and his items are always transported in trash bags. Most of us have never, most of us that have dropped our kids off at college would never fathom dropping them off with trash bags. Or a sleepover in trash bags. These children that would be served by this bill deserve our respect. Maryland Legal Aid urges the committee to pass this bill at a favorable report. Thank you.
Hello, my name is Macy Wilson. Excuse me. I had a piece of paper, but I'm just going to speak from my heart. I'm here to talk on behalf of all other foster care kids, but they're not just kids, they're kings and queens. We are worth it. Why should we feel like trash? You all give us trash bags to put our stuff in. We are kings and queens of this world. Why should I grow up as a little girl feeling like I'm trash? I'm worth more than that. My self-worth is priceless. Should not be labeled to plastic, should not be labeled to mistreating. I'm beautiful. I'm 20 years old, and I'm just finally realizing that. What about all the other little girls and little boys in foster care who haven't realized that yet, or grow up feeling bad about themselves and feel so terrible because we're trash? You show us that we're trash. You give us trash bags to put our stuff in. I was in foster care in Frederick County. This is a totally different county, but I still experienced trauma, abuse, neglect, everything else just like every other county in Maryland. You rarely hear about Frederick County, but it's real. It's in your own backyards. I'm finally going to college and I'm making something of myself in this world. My goal and my job is to speak for other little girls and other little children so they have someone to look up to, so they don't feel so alone in foster care. It was not our fault that we went in. But it shouldn't be our fault that we get treated bad either while we're in care too. I would just like to ask you guys a question. Anyone who has children, grandchildren, nieces or nephews, I have a daughter, she's 9 months. You can never predict life, but how would anybody else feel in this room knowing that your child has their stuff in trash bags, that they're worthless? What if your granddaughter, your grandsons, your nieces and nephews come to you because they feel worthless, because they feel like trash, because our stuff is in trash? I'm a beautiful woman. There are other beautiful little children in the world too. And I just want to thank Senator Charles and everybody here for hearing me. And thank you for listening to me. Even though I'm not in a chair, I don't have a degree, I'm 20. Thank you for listening to me. because you make everyone else in the world feel heard because you heard me. So I just want to extend my great thanks for everyone. Thank you.
A couple questions from the committee. We'll hear from Senator Kelly and then Senator Muse.
And to the woman in green who just spoke, I did not get your name, but I want to thank you for your very compelling testimony. You are obviously a queen and you could be sitting in this chair any day. So please know we believe in you and I thank you for your testimony. My question, I think, is for Senator Charles. I love your bill. I'm moved by your presentation today and I'm heartbroken. This has been in the news a bit, so I was aware of the situation. I'm glad we're working to rectify it. I wanted to know if you had seen the amendment from DHS that they're proposing, which I think it's in the bill file. But it seems perfectly reasonable to me, but I think we're going to hear from them next. So I urge you to take a look at it and make sure you can let the committee know if it's amenable to you. But they certainly are very responsive to the bill and saying that they would like to add language that says that plastic trash bags and disposable bags may not be used, and that sort of modifying the language that you're proposing to expand on it and say, when a child or youth enters care, is moving from one foster care placement to another, or is leaving foster care, the department will provide the child or youth with appropriate luggage, et cetera. Do you have that, or do you need to comment? Do you want to comment on that?
I actually have it. I
Great.
have the written testimony that they have provided with the amendments, and like I mentioned on previous bills, I'm always open and amenable to making changes once I have everybody at the table.
Wonderful.
And that's getting my cross-file sponsor as well as everybody else who are a part of this coalition of making this happen. So I'm definitely open to it.
Thank you so much, Senator Charles, for this bill.
Yes, Mr. Chair, tell me your name.
My name is Macy Wilson.
Macy.
Sorry. Yes, Macy Wilson.
Let me say a couple of things and then I'll ask a question. The sky is the limit for you. No one knows. I'm sure there are others, but I'll just tell them I can identify with you because I was in and out of 11 foster homes, most of them abusive. It drove me to do things I didn't want to do. And there is no word for a feeling like trash. There is no word that anyone can use to deal with being forsaken by family and not knowing why for all of those years. And any way that we can help to be certain that somebody doesn't feel that way, I'm in it 1000% to make it work no matter what. I say that to you to tell you I'm not much, however little bit I am. If someone had told me that growing up that I'd be here, I would have cussed them out probably. I would have thought they were playing with me. I would have thought that I graduated from high school, 21 years old, something like that. And then 20 years old when I finally got out of there. And I kept going. And that's what I want to say to you. And anyone else in your shoes, and you see them down, tell them just keep going. Just keep going. The sky is the limit. And my wishes for you was that you will always carry around what you just said. I am a queen. I am a queen. And you are. Thank you.
Thank you, sir. I would also like to tell you, you're a king. You didn't deserve to go through that, but you're a king too. So thank you.
Sure. Thank you, sir.
It's a great moment. I was telling council, one of the best parts of this job is you get to interface and encounter people just from all different walks of life and different life experiences. And obviously, Senator, intimately familiar with your history and your background, and as is every member of this committee, and just deeply appreciative of your contributions. And Macy, Ms. Wilson, I cannot thank you enough for your testimony, and it was very powerful. And I know it made an impression on all of us. And so we'll be rooting for you if you ever need any help or anything like us.
Right.
I have a feeling we'll be asking you for help soon, but I really do appreciate you coming and offering your testimony. And Ms. Fincauce, I've known you for, I didn't know that. I've known you for a while, and I really appreciate you stepping up and having the courage to testify on behalf of this bill. It's one of these things where like sometimes small imperceptible things that can make a huge difference in someone's life. And so this is a really, really good bill. And I'm, Senator, thankful that you brought it forward to us. So just a bag, but not just a bag. Exactly right. Exactly right. Appreciate it. Thank you all very much. Thanks. With that, that'll
Not call Senator Vogel a millennial, but a Gen Zer.
That's right. I think I'm the oldest millennial, and he'd be insulted that he'd be grouped in the same geriatric age group as a millennial. I don't know. All right, now we've got we'll hear from Secretary Lopez with favorable with amendments from the Department of Human Services. Welcome.
Good afternoon, everyone, actually, or good evening, I should say. My name is Rafael Lopez, and I serve as the Secretary of the Department of Human Services. We respectfully request your favorable report on Senate Bill 668 with recommended amendments to strengthen the bill. And I'd like to take a moment to say a few things on the record, particularly given the extraordinary testimony we just heard from so many people. The thing I do most every day on your behalf on the state is actually apologize on behalf of the state of Maryland. It's the thing I have done every single day since I've taken this job. And part of that is because most of what I end up doing on your behalf as a secretary is cleaning up messes of which I had no hand in making. And I take that job seriously, and I do it honorably on behalf of Governor Moore and the people of Maryland. That said, I would like to invite us to imagine a different world, because normally the Secretary of DHS would come up here defensively and talk about what is or isn't true or fact about what we've heard from all of our advocates. I don't want to do that, because in my own family and the people with whom I've surrounded myself in this role, we all have lived experiences directly in child welfare. And the fact is that the story of this country's child welfare system and bags and garbage bags is actually true. And it happens across this country all the time. I cannot speak to how often it happens in Maryland because I don't have a way to better understand that. But the moment this bill came to my attention, I want to explain a little bit what we did and why we're recommending amendments to the bill. So first off, Senate Bill 668 rightly addresses the dignity of every child entering care or transitioning between out-of-home placements. And these two statements are very important given the actual bill itself. This is not just about entries into foster care. The state of Maryland, as of the 19th of February, has 3,804 kids in its care and custody. But there are oftentimes movements between placements. It could be with a kin mother, a kin grandmother, or a shelter, as we've heard, or others. And each of those merits respect and dignity. So let me be clear on the record as the Secretary of Human Services. No child should ever have their belongings in a trash bag, full stop, never. And yet it still happens. So for example, over the course of the last couple of days, I asked some very simple questions of every single one of our 24 departments of social services. And I asked, do we have a supply of luggage and bags, just like the ones we're up here? Picture after picture after picture confirmed that in every single one of the 24 jurisdictions in the local departments of social services, they're filled with brand new bags, just like the ones here, and brand new suitcases. One might ask oneself, well, then why does it happen, right? It makes no damn sense. But the fact is, it does, because we in this system are humans. And ultimately, we have to find a new way of solving this problem. So I asked a second follow-up question, which is, as the secretary responsible for this department, do we have a policy that's a directive to the people of my department, the 6,000 people in the Department of Human Services over which I'm responsible? And the answer was, we don't. Well, I have the authority to do that. And that change begins now. And that practice will begin now. So such practices of DHS or any of our partners, because as I dug into this and looked into the picture, there's my friend Erica, and asked a very simple question of what day, what child, what county, the only way we'll get to a different kind of Maryland and envision a different place where this is not ever the practice is to name names and times and places. so that we together, the departments of social services, every one of the people who honorably serve this state, and all of our advocacy partners will have a day where this will never happen again. We reached out to the departments, we got the photos confirming that we have brand new bags and brand new suitcases. And though we verified that every LDSS has luggage available at the local level, we also learned that none of them or us as a department have that formal policy. So I want to remind ourselves that ends now. What did we do? We drafted and will issue an immediate policy guidance to all local departments of social services on providing luggage to children and youth in our care, whether at the time of entry, which is what the bill addresses, or during multiple placements. Similarly, we're going to clarify for all of our contracted partners on your behalves, as senators or as members of the House of Delegates, we have a series of contracts with providers across the state. Sometimes the contract is with a private provider who's responsible for the care and custody of the children on our behalf. Sometimes it's a foster parent. And what we've learned in the last couple of days is that across the board, there's inconsistencies in this practice. My take is, if you are an employee of the Department of Human Services, or you are a contractor or vendor of the Department of Human Services on behalf of the kids of Maryland, no garbage bag should ever be used. We don't have language in any of our contracts to hold ourselves accountable for that high level of excellence and standard. So personal luggage, as we've heard, communicates to youth their value. And when we give them trash bags, we say, you are trash. I completely concur, but it doesn't have to be that way. We need to be critical with ourselves about this practice and how it's been allowed to happen, not just in Maryland, but across the country. And we can make that difference if we work together to figure that out. Each LDSS will be required to ensure that all children's or youth's personal belongings are packed respectfully and carefully in appropriate luggage. Our written testimony outlines amendments that we are proposing to strengthen the bill with a trauma-informed approach that ensures no one in Maryland transports children's belongings in a garbage bag. Making sure every child experiencing kinship or foster care receives new luggage when they enter care is of critical importance to this Department of Human Services in this administration. It is also essential that children have appropriate luggage when experiencing a placement change. That's a second piece of what we're suggesting for the bill amendment. As such, the department recommends the bill addresses all children in care, not just at the time of entry, including those who are not in traditional household and those who may be transitioning placements. The department respectfully offers an amendment for stronger requirements during transport between placements, stating, when a child or youth enters care, is moving from one foster care placement to another, or is leaving foster care, the department will assess the child or youth's need for appropriate luggage, taking into account the child or youth's age, mobility, preferences, and the personal items to be transported. Additionally, we recommend adding that plastic trash bags and disposable bags may not be used to transport any items for children and youth in care ever in the state. The department is committed to trauma-responsive procedures. Requiring appropriate luggage for their belongings is an essential part of responding appropriately to the needs of children in foster care. The new policy guidance is another step forward to clarifying our department's commitment to protecting and affirming the dignity of every child and every youth. With your partnership and our recommended amendments, Senate Bill 668 will establish the affirmative obligation for DHS to transport children's belongings with dignity. Thank you for your time, and I'm happy to answer your questions.
Excellent. Well, thank you very much, Mr. Secretary. And we're in receipt of your amendment, and we'll have it drafted for consideration by the committee and the sponsor. Happy you're supportive of putting this into statute, because we know obviously regulation and policy can be changed on a whim, and not everyone's going to be as awesome as you are. So we appreciate that. Senator Charles.
I just wanted to just say ditto to everything that the chair said. You know, not everybody's going to be as awesome as you, and so I'm glad you're willing to also work with us to lock this into statute, in addition to doing this with policy as well. And so I truly commend you, and I commend your passion to fixing this problem and having the conversations with all of the key stakeholders that's in this process. So thank you, Mr. Secretary.
Sure, Senator. And if with the permission of the chair, I am one person. I represent 6,000 people. And I would be remiss if I didn't say that this is a team effort. So what I'm asking all of us to do is reimagine a Maryland where we work differently together. When I say name names, it's not about blame. I know you know that. I have to know as your secretary when it's happening. Why? Because I can get to the bottom of it. And I don't want it to ever happen, but that takes the local departments of social services directors. It includes our advocacy partners. It includes providers. It includes imagining a different way of working together.
Thank you. Appreciate that. All right. Seeing no further questions, thank you very much, Mr. Secretary.
Certainly.
Thanks. All right, I guess you're gonna stay right there because that'll conclude the hearing.
I have another bill, yes.
Yes, yeah. For Senate Bill 668. We'll now move on to our final bill of the day, Senate Bill 708.
My apologies, Chair. Do you want me to go first on the departmental one, or is someone else? Okay. Yeah, it is. This is actually some really great news. Okay, once again, everybody, good evening. I'm Rafael Lopez, serve as the Secretary of the Department of Human Services. We are respectfully requesting your favorable report of SB 708. We are driven by 12 core values that represent the Moore-Miller administration values. And among these values are being data-driven and heart-led, reminding us to rely on data and lived experiences to do our work. Senate Bill 708 establishes a research-informed framework for DHS's kin-first approach to out-of-home placements that will improve outcomes for children and youth experiencing foster care. We are moving urgently forward with a kin-first approach to Maryland. Kin-first policies promote a holistic framework of child well-being. Research demonstrates that foster care placements with kin minimizes trauma, increases the likelihood children will remain with siblings, increases permanency by providing stability with fewer placement disruptions, improves children's behavioral and mental health outcomes, reduces the risk that children in out-of-home care are trafficked, and sixth, maintains family, community, and cultural ties that function as protective factors for children. Ongoing child development research continues to reveal the psychology of childhood bonding and attachment are more expansive than previously understood. Research has demonstrated what we know intuitively. The whole psychosocial environment matters to a child's psychological health and their worth. In short, children don't just bond with parents and caregivers, they also bond with communities and culture. Currently, only 23% of children in foster care in Maryland are placed with kin. Senate Bill 708 would prioritize important childhood bonds, including those found by blood or marriage, when considering the best interests of children who require an out-of-home placement. In 2023, the federal government issued a new licensing rule authoring a different set of standards nationally for licensing kinship caregivers and encouraging state agencies to adopt a broad definition of relative and kin. Senate Bill 708 would clarify the definition of kinship caregiver by including relations through blood, marriage, tribal law or custom, or cultural custom or practice. It would also provide a preference for placement with kin, which evidence demonstrates results in better outcomes for children. We respectfully request your favorable report of SB 708. I'm grateful for your time and happy to answer any of your questions.
All right, seeing no questions from the committee, thank you very much, Mr. Secretary.
Certainly.
Excellent. All right, we'll now hear from Ms. Aubrey Edwards-Luce here. Welcome. Got it.
Thank you so much, Mr. Chair, Mr. Vice Chair, and members of the esteemed committee. My name is Aubrey Edwards-Luce. I am a resident of Prince George's County and the Executive Director of the Sarah and Neil Meyerhoff Center for Family, Children, and the Courts at the University of Baltimore School of Law. CFCC envisions communities where families and children are able to thrive without unnecessary legal system involvement. Now, despite the well-researched benefits of kinship care, less than half of the children in Maryland's DHS custody are in kinship placements. And while CFCC is working adamantly to make sure that we shrink the number of total children in DHS custody, we urge you to support SB 708, a bill that will make Maryland a premier kinship first state with provisions that both advance the best interests of children while also respecting parental rights. I appreciate the committee taking the time to read the written testimony that I provided today, but I'd like to use the rest of my time to share a little bit of a deeper story. I am a hidden foster care fictive kinship caregiver. Years ago, CPS responded to a hotline call involving my goddaughter, and we were given the choice to either have her come stay with us or to have her go into foster care. And we chose to have her stay with us and not become licensed foster care parents, in part because of an issue that SB 708 addresses, namely a lack of a clear kinship first placement preference. Having represented numbers of children in DC's foster care as a guardian ad litem attorney, I knew that if we had become our goddaughter's licensed foster care caregiver, her mother would have to surrender her authority to decide whether she stays with us or goes to another kin care provider. That placement power would reside instead in an agency that may have biases against us or maybe wouldn't see us as the best placement for our goddaughter. So while SB 708 doesn't go as far as to make that placement power be in the courts, it does address this concern by giving a placement preference to kinship providers as well as caregivers identified by parents. I will conclude in saying we stand ready to help remove any barriers to making Maryland a premier kin first jurisdiction. Thank you.
Thank you very much. Questions from the committee? All right, seeing none. Thank you. Have a good evening. With that, that'll conclude the testimony for the proponents of the bill. Okay, that's it. That'll conclude the testimony for Senate Bill 708 and our hearings for the evening.